afternoon. Good afternoon, everyone. My name is Ralph Pincus. I'm serving today as the acting chairman of the Philadelphia Board of License and Inspection Review. Our chairman is not available. We have 3 members of the board present. We are expecting a 4th, but there are 3 members present today. And under the ordinance authorizing the Board of License and Inspection Review, 3 members constitute a panel and authorize us, therefore, to be able to hear the appeals that are listed for today. Some announcements before we proceed so that everyone understands how this operates. If this is the first time you've been before this board, I guess first let me have our members and administrative people introduce themselves. Again, my name is Ralph Pincus and I'm the acting chair.
Roger S. Tennant, Senior Board Member.
Cortez Patton, Board Member.
Sherry, Board Counsel.
Richard Wade, Board Administrator.
Mr. Webster, is he there? Okay, well, these are the people involved this afternoon. First of all, this is an administrative hearing, but it's a formal hearing. So we expect everyone to be attired and conducting themselves and in a place that's appropriate for a hearing. That means a level of privacy for the hearing so that there are no background noises or any other disturbances, that you appear as one should be dressed as if they were at a court session. And if you're in a vehicle, which is okay, that at the time of your hearing, that your vehicle be stopped and you be in a place where it's safe. Also, try not to be walking around while we're in the course of considering these hearings, because that motion is disruptive on the camera. So either close your camera until you get located, as I see someone who keeps walking around, and then open your camera when you're located so you don't be a side disturbance. Did you hear me, Mr. Randall? I guess not. Thank you. If you hear, we're going to hear from city attorneys first to go over the cases, and there may have been resolutions, continuances, agreements that we'll put on the record. There may have been administrative actions making your matter moot or moot complied. They will be read, and in those cases where it's moot or moot complied, we won't be hearing your case. If you need to have an explanation of what that means, on your hearing notice is a telephone number for the board. Please feel free to call the board and ask them for an explanation. And if you don't understand something that's been administratively determined today, also feel free to contact the board. As I indicated, I had 3 screens up with people involved in the hearings this afternoon, which means we have a lot of cases. We actually have a list with 43 cases, many of which have already been administratively resolved. But the fact is that your case may or may not be heard for a considerable amount of time, considerable being an hour, 2 hours. Sometimes we're here till 5:30 or 6 or later. So bear that in mind. I assume you may have seen the list. So just be prepared to wait for a while before your case is heard. Finally, we do provide, and witnesses are presented from the city, and I'll go over this again when the witnesses speak. But if you have questions for the witnesses, you're welcome to ask the witnesses questions. But please remember, if you have an explanation to provide about the issue, we'll hear that explanation. The purpose of hearing from the witness and allowing you to question the witness is for you to ask the witness about anything that they observed or said in the course of their testimony. So just remember that, and I'll remind you if you, in fact, your case reaches that stage.
Excuse me, Chairperson, I
Yes.
apologize for interrupting, but it appears that Board Member Washington has joined the meeting.
Mr. Washington, would you please introduce yourself?
Good afternoon, everyone. My name is Ken Washington. I'm a board member of the Board of License Inspection and Review.
Very good. Welcome. Having given those introductory remarks, the next thing I'd like to do is hear from, there's normally a city solicitor, someone from the law department. There will be on each case an assigned attorney from the law department, but one of the attorneys generally takes the lead and goes over with us those matters that may have been administratively resolved or continued. And please listen carefully because your case may be called. So my first question is, who is the city attorney to do this today?
Good afternoon, Board Member Pincus. Michael Rouleau, RULLO, on behalf of the city, and I'll be handling those.
Very good. Good afternoon.
Beginning with number 11, appeal ending 002835, Jason Wallace, concerning 5111 Wayne Avenue. That matter is moot.
Good. So noted.
Moving to number 19, appeal ending 000159, appellant Meng Zhao, 2815 Fanshawe Street, moot.
Very good.
Number 22, appeal ending 000485, Matthew Bartlett, 1642 Olive Street. My understanding is that appeal has been withdrawn.
I've marked it withdrawn. I have a note, sir, that number 21 has also been withdrawn.
I did not have that on my list, but I believe your list is probably more accurate than mine since you are the board.
Well, all right, we'll wait to see what happens. All right.
Moving to number 25, appeal ending 000600, David McLean, 1422 North 8th Street, moot.
Very good. Noted as moot.
Number 28, appeal ending 001846, SOS Deep Cleaning LLC, 2929 East 2129 East Ann Street, moot.
So noted.
Number 39, appeal ending 004327, 3727 Wallace Street, appellant Vernon Lucas, moot.
Noted as moot.
Number 41, appeal ending 03844. It looks like the last digit has been cut off on my chart, but it concerns 1414 Spark Street, and the appellant is again Vernon Lucas. That matter is also moot.
I have 03844, and I see Mr. Vance in attendance, so I assume he's got that noted. And
Yes, we did email the board, and we both agree that both of those matters are in fact moot.
Very good.
With that, I will turn it over to my colleagues to confirm any settlements or continuances.
I see a raised hand from Sean Logue.
Good afternoon, board members and Chairman Pincus. I have three preliminary matters I'd like to call the board's attention to. The first is case number 12 on our list, appeal number HA 2022-001282. The appellant is Gerald Boyce, doing business as MEB Plumbing LLC, and the address is 1829 Diamond Street. We reached an agreement to resolve that matter, the terms of which are city affirmed with a reduced fine of $1,500. And I sent a copy of the agreement to the board this morning.
Very good. I did see that.
And then I have two continuance requests by appellants, which the city does not oppose. The first is case number 13 on our list, appeal ending in 002218, address 2018 Ellsworth Street, and appellant Ludwin Escalante. I believe I emailed about that continuance request and copied the appellant yesterday. I see he's present as well, so I just wanted to confirm that.
No, the board agrees to continue the case.
All right, and then lastly, case number 18 on the list, appeal ending in 000019, address 10784 Lockhart Road, appellant Ann Siegel. And the city does not oppose her continuance requests as well. I did just want to note that the violation is relatively old, and so the city would request that the next listing, it must be tried.
Well, that's okay. I guess the matter has sort of gotten to the hearing stage at a late date, but under the circumstances, it's 2 years now. I believe I saw Miss Siegel's face for a moment ago, so the case is being continued and will probably be listed for a hearing in December, if I'm not mistaken. Is that correct, Mr. Wade?
That's correct. 12-5.
All right. So please try to see what you can do to resolve it between now and December. Very good. We'll
It's-
continue.
Are
the
we,
case.
is it must be tried?
And we'll mark it must be tried and when it's scheduled.
I did see Miss Siegel present, but I think she's having technical difficulties. I can reach out to her to. let her know.
Mr. Logue, real quick to check on case 13, was that continued? Does he need an attorney at the next listing or no?
Yes, he does.
Okay, so
Yes.
is he aware? So I'm continuing for counsel?
Correct.
Okay,
Let's go back just to confirm. That's case number 13. Involves an LLC.
and he's on the call.
That's correct. Yeah, it's a licensing violation issued to an LLC.
All right, so, and the gentleman is on the call and understands that because it's an LLC, the rules of the board require that an attorney be present, that he be represented by an attorney at the hearing.
That's correct. It's Mr. Escalante. I saw him on the screen earlier. Don't know where he is, but I can call him as well to confirm if he's unable.
Very good. All right, we'll continue the case, but he's unnoticed that he needs to retain counsel. Very good.
And that concludes my business.
Thank you, Mr. Logue.
Thank you.
Let's see who I have next. I have Ms. Nezich from the Water Department cases.
That's right. Thank you, Acting Chair Pincus. I just have one preliminary matter to call to your attention, number 2. That is case ending in 3050. This is for 3553 Wessex Lane. For this matter, the notice has been withdrawn by the Water Department.
All right, it's withdrawn, case number 2.
Thank
And I
you.
believe you're going to try to work with case number 3 in a breakout room.
Yes, I've been in contact with Mr. Wade. I'm waiting on my witness and he will put us in a breakout room when it's a good time.
Very good,
That's all my matters. For
very
preliminary.
good. Thank you. Mr. Johnson,
Good afternoon, Mr. Pincus and distinguished members of the board. There are a few matters I'd like to address with regard to today's hearings. With regard to number 26 and 27 on the list, there was a request to continue. So this is HA 2022-000861 and HA 2022-000933. 222 Brown Street. G&B Construction Group had requested a continuance of the matters earlier this week, to which the city did not oppose. And also there were 2 appeals that were scheduled for the same violation, filed, one by the architect firm, that would be Tina Geary, number 26, and then G&B Construction Group 27. So coming in, the city is asking, were these matters continued?
well, we can grant the continuance today. Yes, we are aware of the request. Does case number 27 need counsel?
I believe it is a corporate entity and I believe it would.
Are they aware of that or have you had conversations?
I haven't
with
had
them?
any conversations with them.
So in the course of between now and the next hearing, you'll make them aware of this requirement?
I believe they're on the call. Someone from G&B just posted a message.
Is G&B Construction have a representative present?
Yes, hello, this is Andrea Ambrush. And yes, I am aware, I just received this letter very late. So now I know that I need to retain a counsel for next time.
Very, very good. All right, so we'll continue these cases and perhaps you can negotiate with the city a resolution before the next hearing.
Sounds good, thank you.
Yep. And she has my email address. I emailed in reply to her message to the board yesterday.
Very good.
Next, I'm going to call the board's attention to the matter at number 21, HA-2022-000411, Jonathan Bagby at 2059 East Allegheny Avenue. I had heard earlier when Mr. Rulo was calling the list, the board chairman had said that appeal was being withdrawn. I hadn't heard that, but I'm going to ask, was that appeal going to be marked as withdrawn?
Yes, it was.
Well,
Board's administration had received the withdrawal notice.
Okay, thank you. So that was number 21 is marked as withdrawn.
very good.
Lastly, with regard to number 25, David McLean, HA 2022-000600. That should be marked as moot.
I believe we did that.
Okay, thank you. I have nothing further.
Very good. Mr. Fernandez, good afternoon, sir.
Good afternoon, Chairman, and good afternoon to all the other members of the board. I have just a few matters to run through, 3 to be exact, starting with number 6 on the list, appellant Four Season MK LLC, appeal number ending in 2679 for premises at 6220 Bustleton Avenue. The appellant in this matter sent an email to board administration, I believe yesterday, saying that they needed more time in order to get an attorney. I did confirm that they are, the cited party is an LLC, as is the appellant. And so I indicated to the board that I did not object to the continuance, but asked that the appellant be informed that they needed to have an attorney present at the next hearing. I don't know if that continuance has already been effectuated or not.
We're aware of the request, but we wanted to hear from the city and we'll grant the continuance request. I assume this is not the same Four Seasons as the one that made the news in the last election round.
Not to my knowledge, I don't believe so. I don't think that Four Seasons Total Landscaping has a tobacco retailer permit.
Yeah. Okay.
Next is number 8 on the list, appeal number ending in 2702, appellant Ramzi Al-Makani, represented by James DeLeon, address 3001 Kensington Avenue. This is another tobacco permit non-renewal appeal. Mr. DeLeon, attorney for the establishment, requested a few days ago an Arabic interpreter for one of his witnesses. When he was told that it would be difficult to arrange for such an interpreter in a short time window, he indicated that he would be okay with the continuance that was suggested by board administration. I think it was to December 5th, if I remember correctly. That's another one where I'm not sure if the continuance has been effectuated or if it was held for the board.
Well, we did receive the request and we're prepared to grant the continuance under the circumstances. I guess my only question is whether there's a dialect or particular language when you use the term Arabic. And that's, I guess, something for the board's for someone to confirm, so we make sure we have the interpreter that has the appropriate skills available.
Yeah, I'm not sure if Mr. DeLeon is here now, but he's been very responsive by email, and I'm sure he could speak to the witness and let board administration know if there's a more specific dialect that he needs to provide.
Very good. We'll continue this case. That's
Thank-
number 8.
Thank you. And last but not least, number 43 on the list, appeal number ending 2912 for 223 South Sydenham Street. I apologize, I don't have the appellant's name in front of me. I left that off of my my spreadsheet by accident.
Prestige Restaurant and Lounge.
Yes, concerning Vesper Sports Club represented by, I believe, Darwin Bouveau. Mr. Bouveau and
It's
It's
Beauvais.
Beauvais.
Oh, Beauvais, I apologize. I see you there. Mr. Beauvais, excuse me, has been in talks with my colleague, Ms. Curley. Ms. Curley yesterday submitted a continuance request to the board with Mr. Beauvais copied, requesting a continuance, hopeful that an agreement could be worked out that would alleviate the board from needing to hear this case. Once again, I'm not sure if that continuance has already been granted or was held for the board at today's hearing.
If I may address the board.
Good afternoon, Mr. Beauvais.
Yes,
Welcome.
good afternoon. And it's always good to see the board members here. Again, for the record, my name is Darwin Beauvais. That's Beauvais, counsel for the applicant Prestige Lounge. Mr. Fernandez is correct that he's not the attorney that's been assigned to this matter. We've been talking to Ms. Carolyn Curley. However, the nature of this appeal is on an emergency basis from a cease and desist on operations. Just not to give too much background, but the Prestige Lounge changed ownership in May and received its special assembly license in July 5th of this year, and was shut down. Their special assembly license was shut down on July 5th of that year. Then we received an email in August saying that the operations are completely shut down. You couldn't operate the restaurant. The board did receive an appeal for the special assembly license, which was denied. That's before council was involved. However, the appeal before the board is on the operations of the restaurant. Now, we are trying to work with the city solicitor. I think this is a situation where immediately when I see that a special assembly license was approved the same day that operations were given a cease and desist, it's clear to me that there were issues prior to the applicant with this business, which I understand. And we're more than happy to work out those issues because like I told my client, sins of the father kind of are befalling the new, sins of the prior owner is befalling the current owner. Nevertheless, this is on an emergency basis. So I do not object to a continuance under the following conditions. If the board can somehow request or do a call hearing for 1 week where we can come back and present our case, because this operation has been shut down for over 2 months. And and we believe it has nothing to do with being a restaurant. That's all what the applicant is seeking, to operate as a restaurant. All the other issues that the city may raise or that was behind the prior appeal, we can work out those issues. But to say that the applicant cannot operate, that's the basis for our emergency. So again, we do not oppose a continuance. However, we don't oppose it under the condition that we can be brought back immediately in 1 week, or in the alternative that we can partially open and still come back and still the board can retain jurisdiction and decide the issues as they may fall at that time. The way yes, and I'm happy to answer any questions.
Well, I don't know that we can deal as a board at this time with the issue of permitting the restaurant to be partially open. I think that's something that you would need to address between you and Ms. Curley or Mr. Fernandez. I assume it's Ms. Curley. And she can then ask the department, I assume, to permit the restaurant to operate while you address the other issues. But I don't think the board can deal with this. Counselor, I don't know that we need to have a special session on that issue.
I understand, but also Mr. Chairman, members of the board, when you look at the fact that the cease operations has crippled my client.
I understand the
and-
business is closed, that they're out of business, and they need the money. They've got a mortgage to pay and taxes and utilities and people that are employed in the city of Philadelphia who pay wage taxes. So I think I understand, and I suspect all of us on the board understand the seriousness of the situation. But I don't believe the board has any jurisdiction unless the matter is heard by it to deal with the temporary lifting of the cease order. Sometimes I think administratively, well, I guess.
Well, I understand. So can we, the way I've seen your calendar, I understand you don't want to do a call, a special session. But I believe your next listing is the October 22nd. If we can be placed on that list, market must be heard. And even, and between now and then, I'm hoping we can come with a resolution that the whole thing by the 22nd is marked moot because we're reopened.
I understand.
If I may very quickly respond, I would certainly have no objection to this being continued to the very next available date. The city also believes that this is time sensitive. We certainly don't disagree with that. I will say, based on my limited understanding of the negotiations, I'm optimistic that resolution can be achieved here shortly. And that's a big part of the reason why I don't object to this being listed for 12 days from now, if that's possible.
October 24th is more appropriate for the board.
Is that agreeable? We'll list it on the 24th of October, and hopefully sooner than that particular day, you will have the matter resolved, which I know you're quite capable of doing, Mr. Beauvais.
Yes, thank you, Mr. Chairman Pink. I guess this is for the board as well as the administrator. Can it be marked must be heard?
Sure. Usually we do it on the occasion that the city is demanding it must be heard. But for you, Mr. Beauvais, we'll mark it must be heard.
Yes.
Mr.
Because
Chair,
I
I have a question.
Sure.
Yes.
I have a quick question. Number 42 is also the same address, of course, different appellants, but are we doing the same thing for both?
Is that the special assembly? Because I believe that was the emergency was denied. But I believe
doing business as the consultant group.
Yeah, and I believe the way I believe the result of the denial, because Mr. Lee filed for an emergency petition, emergency appeal that was denied. Therefore, there's only just a regular. It should be part of their regular appeal list. The emergency was denied, so it should. The way I understand procedure, it should be still alive, but not on an emergency basis. So, Board Member Washington, I think you're right. I don't mind if it will be heard at the same time. And if for whatever reason the restaurant can't follow the same pace as a special assembly, and then we'll just bifurcate again and just can and just
So
have-
the cases are related, and when we call the cases next time around, we'll have
decide.
some clarification as to which if any of them we need to hear. But they'll both be listed for October the 24th as must be tried.
All right, thank you. Thank
Mr.
you, board
Chairman,
member.
I
So
would
in the
only-
meantime, we marking both of these as continued?
Yes.
Thank you.
Mr. Chairman, I certainly believe that the city will be ready to proceed on both of these on the 24th. I have zero indications otherwise, and it's always our preference to go forward when we can. The one caveat is that for appeal number 42 in particular, a police witness may be necessary because it has to do with a special assembly occupancy license denial. And it's a little bit more complicated for us to ensure that the police witness is available. And so I would ask that that specific matter, number 42, not number 43, not be marked must be tried, even though it will be our intent to go forward. And I believe that we will be going forward on that date.
And Mr. Chairman, just on that point alone, that typically is the case. However, the actual form that resulted in the revocation wasn't signed by the police. It was signed by one of the deputy commissioners. So and Mr. Fernandez is correct in saying that it will be hard to get a police officer based on their schedules. It's always a catch can, right? But however, there is no police involved in this matter. There is the deputy commissioner who signed the revocation.
Well, it still may be that as a witness, there's a police officer that the city may propose to call. And if I'm correct, perhaps the first case isn't critical, as critical to the ability to operate the restaurant, as that deals with the assembly issue. Is that correct?
Yes, the assembly does not have to deal with the restaurant, but
All right, so let's just mark the case number 43 as must be tried, but both will be listed for the 24th of October.
and that's fine. And begging the board's indulgence, please, my concern is not based on the process, but based on the uniqueness of how the city has responded to this application. In fairness, when you look at the case, he received his special assembly license the same day he was shut down. And then, and then we're in conversation with the city, and then the city solicitor is unavailable the eve of the hearing. And so we're a little bit nervous. We're concerned. We don't want this matter down the lane, and that it gets kicked down the lane.
We're doing everything we can to try to facilitate getting this matter resolved. We understand, and it turns out my assistant of the last 11 years happens to live on the 200 block of Sydenham Street. So I've been around or near that location a number of times. So I understand where it is and the magnitude of the place.
Thank you.
All right.
So as it stands right now, the cease operation for the restaurant, we're gonna have that marked must be heard. The special assembly, although the emergency appeal was denied, the regular appeal will also be heard that day, but not necessarily marked must be heard.
Correct.
All right. Well, that concludes if the city is okay with that, I'm okay with that, and that will conclude my business.
Yeah,
I believe that Mr. Fernandez,
I have no objection, and I've been doing this long enough to tell that even if I did, it wouldn't matter at this point. We've discussed this long enough. So
we have indeed. We have a
Yeah.
few other matters to consider.
Absolutely.
Let's move on. Thank you, Mr. Beauvais.
Thank you, Darwin. Sorry about mangling your name.
Yeah, no problem. See
Have a
ya.
good one.
I've done it before too.
Bye.
Mr. Fernandez, anything else?
That concludes my matters. Thank you very
All
much.
right, so I think we have Ms. Reinhardt next.
Good afternoon and thank you. I have a very quick continuance to put on the list and I believe it should be amicable. It is number 29 on the list. Appeal ending 003008. This is NM Raheel Properties LLC regarding 2236 North 16th Street. They are represented by attorney Augusta O'Neill, who I believe is present as well. This is an appellant continuance request and the city does not oppose, even though it is an intent to cease. We have looked into the situation and the department is not opposed to the proposed continuance.
Has the property been ceased or is the appeal held open, the action of ceasing?
Mr. Chair, I'm present
Go
this
ahead.
afternoon. My name is Augusta O'Neill. As Ms. Reinhardt indicated, I'm the attorney for the property owner. Just by way of background, my client had purchased this property from someone that told her it was permitted for the group living. Upon investigation, she was surprised to learn when she got a letter from the Department of Licenses and Inspections telling her that in fact it wasn't allowed for that use. So we took the case to the zoning board and attempted to get a variance for multifamily living. We did get the variance and the issue now is my client is in the process of selling the property. So we're trying to work on complying this and getting it mooted so that there's no hearing required. And we are working with Ms. Reinhardt to get that done.
Well, I guess my concern is when we have cease orders, whether we have life and safety issues at stake. And so if a place hasn't been ceased, then we're concerned about that. So I guess my question is the property in use at the present time or has it been ceased?
So the violation has been ceased. The violation was for having multiple, I think it was at the time that the violation was issued, there were 5 or 6 people living there. But I did confirm with my client who's here this afternoon, there is only one person that's living there. And so there's no group living still occurring.
So we don't have an issue of life and safety
No.
at the present time.
There's no
Okay.
issue of life and safety.
All right, so the city's agreeable to continue the matter. Is that right, Ms. Reinhardt?
We are.
Very good. We'll mark it continued.
Thank you.
Thank you
Thank
so
you,
much.
Ms. O'Neill.
Thank you. Appreciate your time.
Next case, please. Do I have anyone else from the city? I do. Ms. Wang, if I'm
Good
saying that
afternoon.
correctly.
Yes, I am here representing the Air Management Services on appeal number 10 on the list, HA 2024002492, 2751 West Passyunk Avenue. That appeal, my understanding is it was withdrawn yesterday. I don't know if that got to the board, but it was withdrawn by the town.
We did receive a note from from a Ms. Nocella saying it's withdrawn because there's an agreement. I guess the question is it just withdrawn or is there an agreement that was entered into?
There is a tentative agreement. It hasn't been executed yet, but yes, that is in the works.
So you want us to mark the case withdrawn?
Yes. Mhm.
Very good. Case number 10, HA 2024-002-492 will be marked withdrawn.
Thank you. And that concludes my business. Thank you.
Very good. Anyone else here with matters to be determined administratively from the city? I don't see any hands. I think we have a couple of cases that we have some questions on as we went through the hearing list for today. I believe the first one I have is case number 14. Is there someone here for case number 14 from the city, HA 2024-002-434, 2939 North 22nd Street? The appellant is listed as Isaiah Morgan.
Yes,
Is
yes, sir. I'm here today. And
I see. And Mr. Bagelman, are you counsel?
yes, Lee Bagelman for the city.
Good afternoon. We're questioning whether Mr. Morgan appears to be the person who filed the appeal, but the entities that are named on the violation notice appear to be an LLC or some sort of a business entity. Is that your observation, Mr. Bagelman?
The city's understanding of this situation is that the license at issue for this license violation notice, Isaiah Morgan individually holds the license. It's our understanding. And so in the violation that was issued lists both Isaiah Morgan's name individually along with the LLC. I believe he's the sole proprietor of, because Mr. Morgan is the license holder that was at issue with this license violation notice. The city does not have a position on whether he needs a counsel for this appeal. The city believes he can proceed today representing himself.
And we would proceed against Mr. Morgan. Is that what you're saying?
That yes, because again, the city's understanding is that Mr. Morgan is the license holder individually for this violation notice.
All right, fine. Then Mr. Morgan is here. We'll hear the case in order. Very good, thank you. Case number 16. That's 7015 Saybrook Avenue, case number HA 2024-002-713. The person filing the appeal is Delilah Calderon, but our records indicate, or the city's indicated, that there might be an LLC involved. Who's handling that case?
This is Michael Rouleau on behalf of the city. So just for clarity, Miss Calderon holds a contractor license in her name, and the licensing violation notice that was issued here was issued to her in her personal capacity. But it appears that Miss Calderon also owns a LLC that is actually the owner, my understanding is the owner of the property. So that's kind of, I think, the distinction. And the city's view is, since this was issued to Miss Calderon in her individual capacity, rather than to the LLC, she can proceed in representing herself if she so chooses.
All right. Well, she is present. I see that she's present. Do you understand, Ms. Calderon, that you have the option always to have an attorney, but you can also proceed to represent yourself because you are the violation was issued to you individually?
Yes, hi everybody. I would like to see counsel. I think that would be the best option for me. I've never done this before, so I would like to have counsel if that's possible.
That's fine. I assume the city wouldn't object
This is the first listing. We will not object to that.
All right, so Ms. Calderon, we'll continue the case. It'll get relisted. In the meantime, you should contact someone to represent you. So maybe you can resolve this matter before the next hearing date.
Awesome. Thank you so much.
Very good. We'll mark it continued. And I guess if we should go back, I see Mr. Morgan was here a minute ago. Perhaps he may want also to seek counsel. So Mr. Morgan, this is case number 14, HA 2024-002-434. We did have you here a minute ago, Mr. Morgan. The city had no objection. I see your face and I think you're trying to figure out how to, there you go.
Sorry, I'm trying to unmute it.
That's fine. So whether you want to retain counsel in this matter, or do you want to proceed today individually? The city has no objection to the matter being presented today.
Yeah. I don't believe I need counsel for this matter, so I'm willing.
That's fine.
Okay.
That's fine. Okay, we'll put you on in the order of the cases as we go through them. Thank you. It'll be a few minutes.
Okay.
Case number 20. HA 2022-000-271, 612 Chew Avenue, Carlos Giraldo.
Hi, it's Christopher Johnson for the city of Philadelphia. I don't believe anyone has appeared today on that case.
Well, it's 1:30 PM. Why don't we call the case? Is a Carlos Giraldo present? Why don't we get this resolved right at this moment?
The city is going to ask that the board mark it as city affirmed failure to appear.
All right, case not Mr. Wade, just to use our normal
This is
procedure.
case 20, hearing appeal ending 0271 612 West Chew, Carlos Giraldo. Give me 1 second. Mr. Giraldo listed 6443 Rising Sun as his mailing address. Notice of this hearing was sent to 6443 Rising Sun on August 26th, 2024.
And okay, and Mr. Johnson, you've asked that the city affirm the violations because of non-appearance. The second most senior member of the panel is Mr. Tennant. Are you able to confirm the time of this action?
Mr. Pinkins, the time is 1:34 PM.
Okay, my vote is city affirmed for non-appearance.
City affirmed for non-appearance.
Mr. Washington, are you?
Excuse me, I'm sorry. I just want to double check. City affirmed non-appearance, is that 1:34?
This is 1:34 PM, yes.
Thank you. City affirmed non-appearance.
City affirmed non-appearance.
The vote is 4-0, city affirmed non-appearance in case number 20. I think those are the administrative matters that we had to consider. I'll just double check, Mr. McSherry, am I right?
Mr. Pinkins, I believe number 23 is a timely issue with that.
Yes,
You're correct. You're correct. You're correct. Who's representing the city in cases 23 and 24 involving 4943 Germantown Avenue, cases HA 2022-006, 000-593 and 000-595?
Yes, good afternoon again. This is Michael Rula on behalf of the city.
We have a question on timeliness. Is someone present on either of these cases? To your the name on the appeal is Christopher Eiffel, if I'm saying it correctly. Christopher Eiffel, are you present?
So
anyone here regarding the properties on Germantown Avenue?
So case number 23 here, appeal ending in 0593 4943 Germantown Avenue, Christopher Eiffel. And case 24, appeal ending 0595 4943 Germantown Avenue, Christopher Eiffel. No one in the waiting room under that name. Mr. Eiffel listed 2317 Brook Grove Road, Bowie, Maryland, as his address. Notice for both of these appeals was sent to 2317 Brook Grove Road, Bowie, Maryland on August 26th.
Board Member Pincus, so, typically we would request that this be marked city affirmed for failure to appear. However, I do want to note that the appeals, both of them were nearly a year late. And one of them actually did, I think I've attached the notice of violation with my packet, used the specific address that the appellant used. So for that reason, I would actually ask if it'd be possible for this to be a city affirm on both bases, that failed to appear and that the appeal is untimely.
Well, we've already, the reason I called the cases is because we had an issue of timeliness. So I guess what you're saying is they shouldn't be heard because we lack jurisdiction to hear the case because of the untimeliness.
That's correct. I would just add that I think that there's two separate bases. There's that, and then the second is that they failed to appear. So I asked that in case they come back. There's two separate bases for the board to render a decision of a city affirm. And for that reason, I think it would be appropriate to render both of those decisions. I obviously would default to Mr. McSherry if he has opinion on that.
And I'll allow Mr. McSherry to advise us.
Yes, I think ultimately it's a matter of, since the appellant is not here to even address or respond to the issue of timeliness, but they are not here, period. I think it would be fair to move forward with sorry, to marking these as a city affirm for failure to appear.
And if there ever is a call to look to on an appeal, there's a transcript, and we've noticed that, and we will agree that these appeals were not timely, but the city affirm non-appearance will be the determination that's made by the board.
Understood.
Okay, so let's get a time and then we'll take a vote.
Mr. Pincus, for appeal ending in 0593, the time is 1:39 p.m.
My vote is city affirmed for non-appearance.
City affirmed for non-appearance.
City affirmed non-appearance.
City affirmed non-appearance.
This is case number 23 HA 2022-00593, 4943 Germantown Avenue, Christopher Eiffel. Next case is number 24. I assume the request again is for city affirm for non-appearance. Mr. Tennant, do you have the time?
Yes, for case ending in 0595, the time is 1:40 p.m.
My vote is city affirmed for non-appearance.
City affirmed for non-appearance.
City affirmed non-appearance.
City affirmed non-appearance.
Okay, city affirmed for non-appearance is the determination in case number 24 with the appeal number HA 2022-00595. I believe that completes all of the administrative matters, and we can, somebody has their hand up. Ms. Calderon, I thought we were continuing your matter.
Hi, so I just wanted to know, should I stay on the call if I'm seeking counsel, or
No,
should I
your
remove
case has
myself?
been your case has been continued, but you're welcome. It's a public hearing, and you're welcome to observe, which might help you in the future for your next scheduled appearance date.
Awesome. Okay, so I'll just remove my my picture.
Very good. Mr. Begelman.
Thank you.
Yes, apologies for not raising this earlier, but I wanted to bring case number 15 to the board's attention. That's appeal number ending 2675, appellant Brett Ashton. I believe the party who received the license violation notice is Ashton CBR. The license holder for that license violation is also Ashton CBR. So it's the city's understanding that appellant Brett Ashton would require legal counsel to proceed with his appeal, but I wasn't sure if the board had discussed that previously.
We did not, I don't believe.
I would just note that again, it's unclear what type of entity this is. If it's a sole proprietorship, and if this is just a fictitious business name, then the appellant would be allowed to proceed. If it's a actual corporate entity, then they would require counsel, but it's unclear what type of entity this even is.
I would add that I know you indicated CBR. In my capacity as an attorney, I don't recall ever using those initials to designate a corporate entity. Is Mr. Ashton present today? Brett Ashton?
Right here.
Mr. Ashton, are you able to tell us what this entity is that's listed on the violation?
To be honest, I was going to ask you what it is. I'm a little contractor who just started off. I recently signed up to do a job for Glue Hospitality on
All right,
22nd and
that's fine.
Washington.
You know, we'll hear more about it. The issue is whether the CBR has any significance, and what you're saying is it doesn't. So we'll hear your case. Well, we actually have an objection that was raised by the city because I believe your appeal was filed 3 days after the 30-day notice in the violation notice. We'll hear your case in order, considering that it was merely 3 days after the deadline. All right, Mr. Bagelman.
Understood.
And it sounds
Thank you.
like Mr. Ashton is here, and he could proceed as an individual.
Thank you.
All right, if we need to, we can explore this a little more when the case is called. All right. So we go back to the beginning of the list, Mr. Wade.
Mr. Rulo has his hand raised.
Oh, sorry about that, Mr. Rulo.
Yes, I just wanted to clarify to make sure there was no confusion, but I'm wondering if Ms. Calderon thinks that the board is going to provide counsel today. And I just wanted to see if we could clarify that, because Ms. Calderon is staying on now. And there was a comment that made me think that when she last spoke.
Ms. Calderon. She said, I believe she understood.
I'm sorry, say it one more time.
Mr. Rulo just wanted to make sure that you understand the obtaining counsel where we've instructed you, or you've asked for us to give you time to retain your own counsel. And we hope you understand that.
Yes, so that means that I would have to get my own lawyer, correct?
Correct.
Yes.
All right. So,
And
so
then
you're welcome to stay on and observe the hearings today, but no one will be counseling you from the city. Okay.
right, yeah, I just want to listen in. This is my first time ever experiencing or seeing something like this. So I kind of just want to get some knowledge. Just so I
That's
could
fine.
know a little bit for next time.
That's fine. That's fine. You're
Okay.
welcome to stay.
Thank you.
Very good.
Alrighty, thanks. Okay. bye-bye.
All right. So, Mr. Wade, I think we're
We can go to the top of the list. I just want to call case 3 and see if the appellants are here. They can go in a breakout room with Ms. Nessich. Case 3, hearing appeal ending 3059 1623 South 17th Street. Dennis Lacavera. I see it, Jennifer.
see Ms. Nysich. Yes. And Mr. Wade, if I may, there's an inquiry in the chat. You may want to see if you're able to respond to it. Is this case number 3?
Yes, I don't see any inquiry.
Well, I see Ms. Nysich.
Yes, right here.
Okay, Ms. Lacavera, I'm going to put you in a breakout room. Is it just
Okay,
you, or
thank
is your neighbor is with you?
My neighbor is not here. No, because we
Okay,
had the
well,
city.
you could
yeah.
discuss it with that way. If your case needs to be continued, it can be continued.
Okay, thank
All right, you saw
In
that
that
prompt.
case, Mr. Wade, I'd like to have my witness that I intended to call for this matter in the breakout room too. I believe he's listed as John Aponte on the call.
Yes.
And also, my matters are listed for 1, 3, and 4. I just kindly like to ask that they be called in order after we get back from the breakout room. I know you're going to hear from one of my colleagues as well.
Anybody over there?
Okay.
All
Okay.
right, so what we'll defer your cases and come back to you once you've completed your conversations with Ms. Lacavara, okay?
Understood. Thank you.
Okay,
Ms. Lacavara, I've given you a prompt to go into room 3. Do you see it?
Yes, so I'll hit join.
Yes. Okay, so that would bring us to case number 5. Case number 5, hearing appeal ending 2635 5200 Woodland Avenue, 5200 Woodland Fuels.
Good afternoon,
Hello.
Michelle. Good afternoon, Michelle Reinhardt for the city of Philadelphia.
is Woodland Fuels present?
Yes.
I see Simon Randall, is that the individual?
I am the attorney.
Who's representing Woodland?
Simon Randall represents Woodland.
Is Woodland Fuels a
Yeah.
corporation?
That
Uh,
case came up, right? But they sent it to the.
Mr. Randall, I can't see you. Do you have
Oh,
a
it doesn't,
camera
but
on
then
your?
she had me mute, so.
Mr. Randall, I'm not hearing you
I hear,
clearly
right?
and I don't
Yeah,
see
I
you.
had joined.
Can you stop and listen to me for a moment?
Chairman, that was not Mr. Randall. That was the inspector or someone from LNI trying to get into the breakout room.
I see. Okay. Okay. Mr. Randall, can
Yes.
you hear me?
Yes, hello, I'm here.
Okay, very good. Is Woodland Fuels, 5200 Woodland Fuels, a corporate or a business entity?
It's just an address. The entity is Ramaco Marketing Group.
I believe Mr. Randall is the attorney for the appellant.
Yes.
I see. Okay. Is the appellant present?
No, they are not.
Are you prepared to move forward for your client today?
Yes.
Very good. Then we'll proceed. Please introduce yourself, though, for the record before we present the case, Mr. Randall.
Simon Randall for Ramaco Marketing Group, LLC.
Very good, Ms. Reinhardt.
Thank you. Jody Wilkins is the representative from the health department here for the city. Would you like to swear her now or
If you're going to call her as a witness, if you're calling her as your first witness, Ms. Reinhardt, then certainly I will swear her in if I only see her on my screen.
Thank you.
There's Ms. Wilkins. Okay. Ms. Wilkins, do you swear or affirm that the testimony you give today will be the whole truth and nothing but the truth?
Yes, I do.
Very good.
Thank you. So calling Ms. Wilkins, can you please introduce yourself for the record?
I'm Jody Wilkins, sanitarian supervisor with the health department, tobacco enforcement.
And when you say tobacco enforcement, can you tell us what you do?
I oversee any sales of tobacco to those who are under 21. And I also provide what they call tobacco retailer permits for the ability for retailers to sell tobacco and e-cigarette products to the city of Philadelphia, to sell tobacco for their businesses here in the city of Philadelphia.
And to do that, you enforce the tobacco retailer regulations as adopted in the Philadelphia Code?
Yes, I do.
Are you familiar whether there was a tobacco retailer permit issued for a business operating at 5200 Woodland Avenue in Philadelphia?
Yes, I am.
I'm going to share my screen with what has been previously circulated, starting with City Exhibit A. Are you able to see just the label City Exhibit A?
Yes.
Okay. Let me know if I need to expand it at all. But City A is a denial of an application for a 2024 tobacco retailer permit dated June 5th, 2024. Can you tell us, did your office send this letter?
I sent that letter for that.
So you're just clarifying you personally did?
Yes.
This was directed to Woodland Fuels operating at 5200 Woodland Avenue. Can you tell us, does it say approximately in the middle of the page who the current owner and permit holder is?
Ramaco Marketing Group LLC.
Okay. And this was a denial of a renewal application for a permit that they already possessed, is that correct?
Correct.
Okay. What was the basis for the denial?
The business sold to minors 3 times, or someone under 21, 3 times in 2 years.
And when you're saying 3 times, you don't mean three minors in one day, you're talking 3 separate dates?
That's correct.
Okay. And in approximately the middle of the page, did you list the specific violations at issue?
That's correct.
Can you tell us the dates of the violations and the types of violations that were found?
Yes, so on February the 2nd of 2022, there was a sell of tobacco to a minor and sell of tobacco without checking the ID. And that was the first violation. The second one was September 20th, 2022, of a sell of tobacco to a minor and then sell without checking the ID. The third violation of June 16, 2023, sell to a minor and then tobacco sell without ID.
So just to be clear, as a result, there were 3 separate dates of incidents of violations. Is that correct?
That's correct.
I am scrolling down to what has previously been marked City Exhibit B. This is a collection of the code violation notices. First of all, are you familiar with these?
Yes, I am.
Are these the code violation notices issued by your office that were described in the denial letter?
That's correct.
Okay. Let me know again if I should zoom in at all in order to let you read anything more clearly, but can you tell us, there are 2 code violation notices on this first page of Exhibit B. Can you tell us what dates these are for?
For February the 2nd of 2022.
Okay. For both of them?
Yes.
And do you know how these were served to the business?
They were served individually. I mean, they were served in person by the person's name at the bottom of the ticket.
And if I am now scrolling down to the bottom, are you able to tell us who that is?
Yeah, that's Martha Davis, M. Davis.
Do you know the specific date that the business was served?
At the bottom, it says March the 9th, 2022.
So what you're saying is that M. Davis went and actually handed someone, you said at the business, what does that mean?
I mean, they went into the business, talked to the clerk, whoever was there, and issued them the ticket.
When you're saying the business, you mean 5200 Woodland Avenue?
Yes.
Okay, so someone from your office went to this address while they were operating, handed it to the clerk, and served the business personally?
Correct.
Okay, moving to the second page, there are 2 more code violation notices. Can you tell us the date of these notices?
September 20th, 2022.
And scrolling to the bottom, can you tell us the date that or can you tell us how these notices were served to the business?
They were served in person to the business. That's my name, Jay Wilkins, on September 28th, 2022. They were issued to them directly at the business I issued them to a clerk.
And moving to the third page of Exhibit B, these again are 2 more code violation notices. Can you tell us the date of these notices?
That's June the 16th, 2023.
And scrolling to the bottom, can you tell us how these were served to the business?
I issued them, Jay Wilkins, on 7/11/23. I went into the business and gave it to the clerk, issued the tickets to them directly.
Before issuing the denial letter, did you check whether any of the notices that we just looked at were administratively appealed or paid?
Yes, I did.
Okay. Moving to City Exhibit C. Again, I do understand that the type font is small. Please let me know if I should zoom in at any point in time. But is Exhibit C?
Miss Reinhardt, if you want the board members to be able to read it, you need to make it larger.
Okay, thank you. Is that good for now?
Yes, very good.
Okay. Ms. Wilkins, is City Exhibit C a printout of the record of outcomes for payments and administrative appeals?
Yes, it is.
For these code violation notices that you just referenced?
Yes.
Okay. When was this printed? This week?
Yes.
Okay, so it could include more updates than when when you issued the denial letter. Is that fair?
That's fair.
Okay. Were any of these notices appealed?
Yes, they were.
Okay, starting from the top, can you tell us which ones were appealed?
The first 2, the ones that's ending in 515 and 526. The appeal was done, the request for an appeal was scheduled on April the 5th of 2024. And they failed to appear and they were not paid.
Okay. And just so that I'm making sure that I'm matching what's on the screen with what you just said, when you referenced the notices ending 515 and 526, those are the top 2 lines of this table?
That's correct.
Okay, so scrolling over, when it says disposition, FTA for both of them, on the far, I'm going to say approximately the middle of the page. That is the failure to appear that you noted?
Yes.
Okay. And as a result of failure to appear, what effect does that have on the administrative appeal?
Meaning that they did not appear, therefore the tickets still stand and undisputed, and they did not pay.
Okay. Turning to the next tickets, I believe this would be in approximately the middle grouping, tickets ending 123 and 134. Can you tell us whether these were appealed?
Yes, they were. The hearing date was 8/11/23, and they were found liable for both.
Indicating that someone showed up and they lost the administrative appeal?
Yes, correct.
Okay. And then the final 2 notices, ending 140 and 151, were any administrative appeals filed for those notices?
No, they were not.
Okay. Were any of the 6 notices here paid?
No.
So your testimony, just in summary, is that the first 2 notices on this list were appealed, but they lost because no one showed up. The next 2 were appealed and they lost, even though someone did show up. And then the last 2 were not appealed at all. Is that correct?
That's correct.
I'm going to zoom out just a little bit. Showing City Exhibit D. Is this a copy of the tobacco regulations that you enforce?
Yes.
Okay, I am not going to read through those in their entirety.
Is it necessary, Ms. Reinhardt, that you read through the regulation in its entirety, or you just refer to the penultimate provisions that apply?
I am just going to reference that they are there, so that you, it is in the record that, Ms. Wilkins, these are the guidelines, that she enforces.
Fine.
Thank
So I don't
you.
know if that's for the record.
As a result, Ms. Wilkins, there are 3 incidents of violations that were referenced in the denial letter. It's your position that as a result, can rather the city health department issue the tobacco retailer permit when there are 3 violations within the last 2 years?
No, we cannot issue a tobacco permit based on those violations.
Okay, I have no further questions.
Very good. Mr. Randall, do you have any questions for Ms. Wilkins on cross-examination?
Very briefly.
Please proceed.
Ms. Wilkins, today, the evidence that you are submitting are the documents associated with the tickets issued by the police officer, correct?
There weren't police officers, there are health department staff.
Okay, but is Ms. Davis available for me to cross-examine today?
No, she's no longer working with the health department.
Is the decoy, as I call them, the decoy that Ms. Davis used to allegedly buy tobacco available today for me to cross-examine?
Is that the city just objects to any reference to a decoy?
Well, I guess if I understand this correctly, the appeal is taken on the letter that's a denial of the application. We're not here today to hear the determinations with respect to the individual violation or citations that were issued. Those matters were adjudicated, if an appeal was taken, they were adjudicated administratively at a separate, or an opportunity to have them adjudicated occurred at a separate hearing. So we're not here as a board today to hear any argument raised with respect to the violations that have been issued. That's a separate matter, and that's been dispensed with.
Then I guess I would close by saying that the fines are excessive and I would request that they be reduced appropriately.
Well, again, we're not in a position to do that because the appeal is not with respect to the determinations that were made administratively with respect to those citations. What we're here is whether or not the denial of the application was appropriately made. Any issues involving fines or fees issued by the city is normally appealed to the Tax Review Board for the city of Philadelphia. Our issue today is that your client has chosen to challenge the denial of its application for a tobacco retailer permit for 2024. So again, you have no further questions from Ms. Wilkins, is that correct?
Correct.
Very good. Ms. Reinhardt, any redirect?
None.
All right, Mr. Randall, you don't have a witness, or if you have a witness, do you just have argument you want to make? If you do, then we'll hear your argument, and then we'll let the city present its argument, and we'll make a determination. You have a witness?
No, I do not have a witness, but I would be repeating the argument that I guess I was trying to make, is that I don't have any witnesses provided by the city to cross-examine regarding the facts that led up to the tickets and the denial of the renewal of the license. So I am without evidence to rebut.
I see. Let me just a moment, please. My apologies. All right, Ms. Reinhardt?
Thank you, Mr. Chairman. I believe that the record here is clear. There are 3 separate incidents of violations. 4 of the 6 tickets were appealed, indicating there was actual notice. To the extent that, you know, as you pointed out, the facts regarding the individual tickets are not in dispute here before the board. The time for those administrative appeals was previously, and in fact, appellant did file administrative appeals, also indicating actual notice of each of those tickets as well. So those are settled. As a result, I am asking that you affirm the city's determination in denying the renewal application. Thank you.
Very good. Having heard testimony and argument, we'll vote the matter. My vote, in case Mr. Well, I'll call the case number once I find it. Just a moment.
Case number 5, hearing appeal ending 2635, 5200 Woodland Avenue.
My vote is city affirmed.
City affirmed.
City affirmed.
City affirmed.
City affirmed unanimously, 4-0. That concludes the case. Thank you very much, Ms. Reinhardt and Mr. Randall. The matter is concluded.
Yeah.
If you wanted, Mr. Randall, the letter with the decision will include information about how to appeal the determination of the board. Okay?
Yes,
Thank you,
thank
sir.
you very much.
Mr. Wade, the next case.
Preliminarily, I just received, I overlooked the email. Cases 30 through 38 will be marked withdrawn. There was email correspondence dated September 5th to that effect from Mr. Coffey, attorney for Speedway LLC.
Yeah.
Okay, do we, I guess because they're withdrawn, I don't know that we need to recite the case numbers, do we?
Just to be clear, are we talking 30 to 38?
Correct. They're all cases in which Hal Coffey was listed. They're tobacco cases in which Mr. Coffey was listed as the attorney representing Speedway LLC.
Good afternoon, members of the board. Will Fernandez for the city of Philadelphia. I negotiated a master settlement with Mr. Coffey that covered all 9 of these appeals and resulted in all of them being withdrawn. I'm on the emails as well that effectuated sought to effectuate the withdrawal. If the board determines that the appeal numbers need to be read into the record, I'm happy to do that.
Well, I don't think we customarily read them into the record, so unless I'm overruled by administrative or my counsel, we'll just note it in the file.
I mean, I guess I just want to be clear. If is it withdrawn pursuant to a signed settlement agreement? I think that probably should be noted for the record.
Mr. Fernandez, is there a settlement agreement?
Yes, there is a executed settlement agreement that I don't think we necessarily need to submit it to the record or put it on the record, but the result of that agreement was Mr. Coffey contacting the board and requesting the withdrawal of all of those Speedway appeals that are listed for today. I think 9 in total.
I would say that is sufficient. Thank you.
Very good.
Thank you,
All
Mr.
right,
Terry.
so it's not the typical settlement agreement as
Correct.
correct. Very good. We'll note cases 30 through 38 as withdrawn. And we'll go back to the list. I don't know whether Ms. Nysich is here or whether we should proceed with a
Ms. Nessich is back, and I believe she has a preliminary resolution to read into the record.
I do. Thank you, Mr. Wade. As to hearing appeal listed number 3, 1623 South 17th Street, appellant's name Dennis Lacovera, ending in 3059. I got a chance to speak with the petitioners in the breakout room, and they've agreed to a city affirmed with a 90-day stay of enforcement.
okay, are they still on
She
with us?
wanted to jump off and consented to me reading it into the record.
I'm sorry, say that again, please.
She wanted to leave the meeting, so she asked me to read it into the record.
Okay, so for case number 3, there is a settlement agreement.
Yes, city affirmed with a 90-day stay of enforcement.
Very good. Well, so noted. Then I guess we're ready for you to be, are you ready to present the first case?
Yes, sir.
It's case number 1, hearing appeal ending 2942, 6051 North 12th Street. Barbara Rembert. Barbara Rembert.
Is there anyone present for the property at 6061 North 12th Street, Barbara Rembert?
6051.
6051 North 12th Street. I do not hear a response, Miss.
Notice of this
Nessich.
hearing, Ms. Rembert listed 6051 as her mailing address. Notice of this hearing was sent to 6051 North 12th Street on 8/27/2024.
There's no one here. What would you determination would you like, Miss Nessich?
City affirmed for failure to appear, please.
Very good. What time, Mr. Tennant, do we have?
2:16 p.m.
My vote at 2:16 p.m. is city affirmed for non-appearance.
City affirmed for non-appearance.
City affirmed non-appearance.
City affirmed non-appearance.
So the vote is city affirmed for non-appearance. And I didn't mention it earlier, but with the presence of Mr. Washington, we now are no longer a panel, but a quorum for purposes of proceeding with these hearings. Ms. Nessich, I guess, Mr. Wade, call the next case, please.
This is case number 4, hearing appeal ending 3150 6503 North Bouvier Street, Carrie Ann Wong Jacobs.
I believe I see the lady on the screen. She needs to unmute herself or be unmuted, whichever is the case.
Yes, good afternoon.
Good afternoon, Ms. Wong.
Yes.
Or you how do you prefer to be referred to?
It doesn't matter.
Okay. Ms. Wong, would you please raise your hand? The right hand, please? Thank you. Do you swear or affirm the testimony you give today will be the whole truth and nothing but the truth, so help you? So you swear or affirm that the testimony you give today will be the whole truth?
Yes.
Thank you.
And
Miss,
Mr. Pincus, I would like to call Mr. William Patterson as witness as well, if you can swear him in.
sure. Mr. Patterson, I see your face. You have to unmute yourself or be unmuted.
No,
Excuse me.
no, there's somebody's here.
Yes, thank you. Mr. Patterson, could you raise your right hand, please? Do you swear or affirm the testimony you give today will be nothing but the truth?
Yes.
Very good. Ms.
Thank you. May
Nyssen,
I proceed?
you may.
Thank you. Good afternoon again, board members. For this matter, the Philadelphia Water Department issued an NOD for a defective lateral to the property at 6503 North Bouvier Street on July 23rd, 2024. The lateral pipe from the property was found to be defective per the results of a dye test performed by the Water Department Sewer Maintenance Unit pursuant to 53 PS 14794 and the Philadelphia Plumbing Code. The sewer lateral are owned by each property owner and must be maintained to a level of adequate drainage. As of the Water Department's most recent reinspection, no repairs have been made to the defective lateral and no permits have been issued to the property. And the city would like to call Crew Chief Mr. William Patterson as its witness.
Very good. Mr. Patterson, you've been sworn in. Please proceed.
With the board's indulgence, may I share my screen, please?
Sure.
Thank you. And can everyone see that all right?
You may need to make it a little bigger.
Okay.
That's good.
Okay. Good afternoon, Mr. Patterson.
Good afternoon.
Could you
Mr.
state your name
Patterson,
and title for the record a little bit loudly, please?
Yeah, either speak louder or
William
get close.
Patterson.
Very good.
William Patterson, Sewer Maintenance Crew Chief.
Thank you. And how long have you been employed by the Water Department?
4 years.
And you are in the sewer maintenance unit?
Yes.
Are you familiar with the property at 6503 North Bouvier Street?
Yes.
And we're looking at right here a street investigation work order for the property in question, correct?
Yes.
Okay. I'm going to scroll down a little bit, but first, I'm going to put my mouse around it. What was the work order or the street investigation investigating here? Can you see that here?
The streets investigated a depression.
Right.
At 5603 North Bouvier Street.
Right. And I'm going to scroll down next to the NOD. Can you please explain what this NOD is noticing the property owner for?
It's a notice of plumbing defect for a defective lateral.
Right. And what is the lateral?
Just a moment, Ms. Nysich. As I noticed, the violation has David Joe Jacobs as the named party at 6503 North Bouvier Street. I just want to confirm before we proceed, Carrie Ann Wong Jacobs, are you an owner of this property?
Yes, I am.
And Mr. Jacobs is also an owner of the property?
Yes.
Is he here today?
He's at work, but the notice came to me, so I'm not sure
That's
The
fine.
hearing came to me.
No, that's fine. He's an owner of the property
Yes,
and
it's
you,
my-
and you are an owner of the property
Yes,
as
it's my
well?
husband, yes.
Very good. Okay, let's proceed.
Thank you. I'm just going to ask you a few questions about how the sewer maintenance unit determined that the lateral was broken. So it says that there was a dye test performed and dye was placed into the cave-in or the depression. Can you just explain really simply how that works and how that determines if a lateral is broken?
So when we get there, we discovered the cave in. We ran water and put some dye in the cave in. The green dye that gives us a determining factor of what's defective in a way. So we dye test the cave in, the dye showed into the sewer, and then one of my guys have to crawl the sewer, and we ID that it was the lateral of 5603.
Someone physically ID.
Physically ID'd, yes.
Okay. And were you on the site that day or did you just review this NOD?
Yes. I was on the site, yes.
Okay. And you reviewed all of the records regarding this property?
Yes.
And these records are made and kept in the ordinary course of Philadelphia Water Department business?
Yes.
Right. Finally, I'd like to scroll down and show, well, not finally,
Excuse me,
second
Ms.
to last.
Leslie, if I may, can you scroll back up to the top of that
Yes, sir.
exhibit? Thank you.
Yes. The top of the NOD?
Yes.
Would you like me to make it bigger?
Yes, that's fine. Come down a little bit more. Yes, a little more. Okay, I think I may have overlooked. All right, thank you.
Next, let's take a look at this report. Mr. Patterson, what are we looking at here?
City Works report.
Right, and these are reports of when you visit the property and if there's a defect found?
Yes.
Right.
Yep.
Here we have recorded the dye test in front of the property, correct?
Yes.
Right, and here, what does this mean? Dye shows pause in sewer.
Dye show positive in the sewer through defective lateral at 5603 North Bouvier Street.
Is that 66 or what it says on the letter is 65?
6503.
Okay, thank you.
And it appears there was another reinspection made, and no repairs were found. Is that correct?
Yes.
Right. Finally, I'm gonna scroll down one more. This is
Ms. Nysich, would you mind
Yeah.
going back? Is there a date reference for when that inspection was made?
Sure. It appears that the reinspection was made 9/9.
Are you able to confirm that, Inspector?
Yes.
Okay, thank you. 9/9 of 2024.
Of this year, yes. Moving on to the customer responsibility chart. This is just a diagram of what typical lateral configuration looks like, correct?
Yes.
And here, I'm gonna make it a little bit bigger. Here we can see the sanitary and storm lateral. Can you tell us which letter is associated with the defect on this chart?
D.
Yeah. I wasn't sure if you could see that. Thank you. And Mr. Patterson,
Could you repeat that again? Which letter are you referring to?
D.
D as in David.
D, yes, D as in David.
Thank you.
That refers to the sanitary and storm lateral. And Mr. Patterson, who's responsible for maintenance of the lateral?
The homeowner.
Right. I think that I have nothing further save to ask the board to mark and move into evidence what's been previously marked as City Exhibit 4.
Exhibit 4 will be admitted.
I have nothing further.
Very good. Ms. Wong, this is your opportunity to, we say cross-examine, which means question the inspector on any of the statements he made or any statements or information that's been presented that he's relied on. You'll have an opportunity to talk about your reasons for appealing. This is your opportunity to ask the inspector questions about the statements he's made. You understand?
Okay, so number one, we bought this house almost 5 years ago. And since we have bought this house, that's.
No, wait a second, Ms. Jacobs. Again, I don't know whether you heard what I said. If you want to talk to us about your circumstances with respect to the property, you'll have an opportunity to do that. Do you have a question for Inspector Patterson regarding any of the statements, his inspections, what they saw, what the report is? Do you have a question for him?
I'm really not sure what's happening right now. This meeting is about me asking him a question about what he saw, or do I get to talk about what's going on with me?
You get to talk about what's going on, but the first thing we heard from is an explanation so that the board understands what has happened and why the city believes you need to make a repair to the property. So this is your opportunity to question this gentleman as to whether any of the information that he's presented is accurate or not. And if you have questions about what he said, you can ask him questions. If you don't have any, that's fine. Then you'll have an opportunity to tell us and provide us with your explanation of what you think is the situation and how it needs to be addressed.
I do not have any questions for Mr. Patterson at this moment.
Very good. Very good. Then this is your opportunity. Please tell us why we know why you filed the appeal. You said it's not the fault of the homeowner and it's a city responsibility. If you want to explain to us why you believe that's the case, please do.
Okay, so as I was saying earlier, the property, the entire Bouvier Street that I live on, they have several issues of holes all over, where the city keeps coming back and forth and fixing and then destroying and fixing and destroying and fixing. Right now, that defect that he's talking about, that hole, is not even there anymore. I sent an email today with pictures, recent pictures, and I do not feel that it is our responsibility to fix this. This should be between the city and the water department. I feel as if, as a homeowner, I'm being caught up between both parties. And the street needs to be fixed in full permanently, because over the years since I've been here, our neighbors are constantly having the city and the water department back and forth doing construction. I don't know what is happening, but I believe this is unfair. I believe this is wrong. And I believe that this is an exploitation on me as our own house owner of this property. And
Okay.
I do not have a personal plumbing problem right now. I don't have a problem. The hole or the lateral that he's talking about is no longer even exist based on my pictures and observation and video that I sent this morning. And to be sent a notice and being told that I am to fork out money, and also being threatened with a shut off, also being told that I must take out a loan and get a lien put on my house. This is grossly inappropriate and very wrong as a resident.
Okay, so Miss Wong, you perhaps should consult with, if you haven't, a plumber. What the city has said to us by the statements of Mr. Patterson and their records is that there was a hole in the street. There was there were tests made, and they found that one of the reasons there's a hole is because the water from the lateral, which is a pipe that connects your house to the storm sewer, it was broken. And that means that it's not going directly into the pipe, to the storm water pipe, but it's going under the street and causing it to break. The fact that it may have been repaired doesn't mean that the street may have been repaired, doesn't mean that the lateral pipe that they found to be broken that connects to your house has been repaired. And the only thing you could do would be to have someone come out and make a test and determine whether or not your lateral is in fact defective. The city believes it's defective, and you haven't presented any information today to suggest that it isn't defective. So the only thing you can do is hire a plumber and see and determine if it does need to be repaired. And if it does, then it's your responsibility to get it repaired. So we can't make a determination. Our determination has to be based on the information that the city's presented today. We've heard your argument. Does the city have anything further it wants to add under the circumstances?
Just maybe 2 additional questions for Mr. Patterson, if that's all right. Thank you. Mr. Patterson, is the notice of defect asking the property owner to repair the hole in the street or only the lateral?
No, only the lateral.
Right. And one more final question. Can, as Mr. Pincus mentioned, can broken laterals seeping untreated wastewater into the
So,
groundwater, can that cause a depression or a sinkhole?
Broken laterals, yes, broken laterals will do nothing but just cause, like you said, cave-ins and depressions because they work like vacuums. Every time she uses water and flush her toilet, it'll suck all the dirt and stuff down back into the sewer, and it'll cause another hole.
Right. And actually one more final question. If someone has a broken wastewater sewer lateral, would they necessarily have plumbing problems or pressure problems inside the house?
No, not at all. Nope.
Okay, that concludes my questions for Mr. Patterson.
Mr. Chair, I have a question for Mr. Patterson.
Sure.
Yes.
Mr. Patterson, when was the last time you inspected the property?
When was the last time I inspected the property?
Yes, she made a statement that it's been repaired, so I'm just curious when the last time you inspected the property.
She said there's been repairs to the street. Maybe streets came and repaired the hole, but that's not a repair on the lateral.
When was the last time you inspected the property?
The last time I inspected the property, I can't give you the date off the top. It's been a minute ago. We're in October. I have 1,000 jobs a day, boss. I'm sorry.
So just at this point right now, you don't know whether it was repaired.
Mr. Washington,
out here.
Mr. Washington, I believe there was testimony that there was a water department inspection on the 29th.
If I'm not mistaken.
On the 9th of
If I may,
September.
I can pull the record back up.
It said the 9th of September, if I'm not mistaken. The 9th of September, and the homeowner just stated that she didn't get any repairs done.
So the last time the property was inspected was in September?
Yes.
So at this point in time, because this is October, it could have been repaired?
The hole in the street might have been repaired by the streets department. Her lateral has not been repaired if she hasn't got a plumber to repair the lateral. So the lateral is still broken and defective.
So you would know that she got a plumber because you would have a report, correct?
Would I know if she had a plumber? If she had a plumber, we wouldn't be in this deposition now if she had a plumber.
But you would have had a report, correct?
Yes.
Okay,
Mr. Washington, if I may pull up the work report that I showed earlier, it indicates that when the reinspection was done, a permit check was performed on the system, And no permits were pulled for a dig up of the street in order to repair the lateral. So that's how Mr. Patterson would know there have been no repairs made. I can show that
Thank you.
again if it would be helpful.
Thank you.
Very good. Are you satisfied, Mr. Washington?
Yes, sir, Mr. Pincus.
Very good. Do we need to have a brief executive session? Or are we okay to vote?
If you're asking me, I'm okay to vote.
All right,
So,
then,
excuse me, before there's a vote,
yes,
I was told that I should not go ahead with any plumber until there was this hearing. So we were told to wait to see what's next to do. That is why there was no plumber, because I am trying to appeal this because I do not believe that this is fair. There's this proof of whatever proof that he said that he has. I didn't get that proof. I mean,
we can, I think, as a consequence of the fact that you haven't taken action, we can take a vote today and ask that the water department to stay action and give you some time to try to engage your own plumber and get this resolved by someone you engage within, I would contend 60 days, if that's okay. So I would recommend that we, if the rest of the board votes, as I believe they will, to affirm the action taken by the city, we'll also add that there'll be a 60-day stay of enforcement, recommend a 60-day stay of enforcement, which would give you some time to engage the services of a plumber to come out. And I suspect if you work with the water department and that plumber requires additional time, that may be something that can be worked out as well. Okay, Ms. Wong?
okay.
So let me call the vote. My vote is city affirmed with a 60-day stay of enforcement.
City affirmed with a 60-day stay of enforcement.
City affirmed 60-day stay of enforcement.
City affirmed 60 days stay of enforcement.
So can I also confirm that I will not get a shut off within that 60 days?
I see Ms. Nysich nodding her head.
The water department always reserves the right to shut off if there is some sort of emergency or a health and safety concern. However, we will not shut it off based on the result of this hearing, and we will hold for 60 days. Of course, if there is some sort of emergency, that would change the situation, if that makes sense.
And I have one final question as well. Being that the hole no longer exists, are you saying that my damaged lateral may cause another hole? Because I was told that my lateral could cause an accident or something because of a small hole, actually, which I sent the pictures. So are you saying that in future that another hole will present itself?
I think you're going to have to get, I don't know that based on what you've heard today, that question can or should be answered. But obviously the lateral means the defective lateral means that the water is not going to where it should be, and that the underlying the street is not secure. So you have to proceed. The word I use is expeditiously to try to deal with this situation. Okay?
Okay, thank you.
Thank you. Have a good afternoon.
Yes, thank you.
Ms. Nysich, I think that's your cases. Is that correct?
That is, sir. May my witness be excused?
Absolutely.
Thank you.
Acting Chairman Pincus, may I be heard briefly? I want to try and administratively shorten your list.
Mr. Maynard, I think you've been here before.
Yes. So I'm here on appeal HA 2024-002693 regarding 8601 Tarsdale Avenue.
Case number 7.
And my client has informed me that he wishes to withdraw his appeal, and I believe Mr. Fernandez would not object to that.
Certainly no objection from me.
Very good. We'll mark it on the file as withdrawn. Case number, just to make sure, Mr. Wade, would you call case 7?
Case 7, hearing appeal ending 2693. 8601 Tarsal Avenue, Unicor Mattel.
And I'm not sure with the name, whether it's a man or a woman, is represented by Mr. Maynard, who has informed us of the intention of the appellant to withdraw. And we accept that. Thank you.
Thank you. May I be excused?
Absolutely.
All right, have a nice day.
You too.
Case number 9. That brings us up to case number 9. Hearing appeal ending 2747, 7965 Varee Road, Three Brothers Convenience.
Oh. Good afternoon.
Bart Levy for the appellate.
Good afternoon, Michelle Reinhardt for the city of Philadelphia.
Very good. Miss Reinhardt, do you have a witness? And Mr. Levy, do you have a witness?
I do.
And Miss Reinhardt?
I do. It's going to be Ms. Wilkins as well.
I see. Okay. Ms. Wilkins, you've been sworn in, so we don't have to do that again. Mr. Levy, is it Levy or Levy?
Levy.
Very good. Your witness, please.
My witness. Oh, I guess my witness is Mr. Shaw, the owner.
Okay, and is he going to be testifying so I can swear him in?
Certainly.
Mr. Shaw, would you I see you in the background. I hope I can hear you. Would you raise your right hand? And do you swear or affirm the testimony you give today will be the whole truth and nothing but the truth?
Yes. Were you able to hear that?
I'm sorry, someone spoke.
Were you able to hear that?
Yes.
Thank you, Mr. Chair.
Ms. Reinhardt?
Thank you.
You may proceed.
Thank you. This matter is once again regarding a denial of a tobacco retailer permit renewal application for Three Brothers Convenience Incorporated, doing business at 7965 Verde Road. And for the record, that is spelled VERREE Road. Ms. Wilkins, can you please introduce yourself for the record?
Jody Wilkins, sanitarian supervisor with the Health Department, Tobacco Enforcement.
And as part of tobacco enforcement, you enforce the regulations of the city of Philadelphia and all tobacco regulations adopted in the Philadelphia Code?
Yes, I do.
Are you familiar with the tobacco retailer permit issued for a business at 7965 Verde Road?
Yes, I am.
I am going to share my screen with what has been previously circulated as City Exhibit A. Ms. Wilkins, can you please indicate when you see Exhibit A on your screen?
I see it.
Okay. I am showing you a copy of the denial of the renewal application for the 2024 tobacco retailer permit dated May 30th, 2024, issued to this business. Can you please tell us, first of all, the current owner and permit holder indicated for the top of the page?
That's Three Brothers Convenience.
Jesus Christ.
I'm sorry, can you repeat that?
Three Brothers Convenience Inc.
Thank you.
And what was the reason for the denial?
The business had 3 violations of selling tobacco under 21 3 times in 2 years.
Okay. Are those are those instances documented by code violation notices?
Yes,
And are those code violation notices listed and documented in the middle of the first page of the denial letter?
yes, it is.
Okay, can you please read us the date of the notices reference?
Objection.
What is your objection?
I'd like to see the notice itself rather than hearing it described. The best evidence the notice would be an example of it.
Well, I believe in the course of the presentation, Ms. Reinhardt will use them and present them as exhibits. Maybe not.
They speak for themselves, wouldn't they, Mr. Chairman?
They would, but Ms. Reinhardt, do you intend to present the copies of the violation notices?
I do.
The citation.
If we can skip ahead, Mr. Levy, would you stipulate that there were 3 separate dates worth of violations noted on the denial letter?
This one in front of us now, right?
Yes.
Sure, the 19th of April, the 20th of June, and the 10th of June of 23.
So I think the objection is was sustained in the sense that you answered that they will be presented.
Okay.
Moving to City Exhibit B. This is a collection of code violation notices. Ms. Wilkins, the first notice on your screen is dated April 19th, 2022. Are you familiar with this notice?
Yes, I am.
Okay. Can you tell us what this was issued for?
A tobacco sale without ID.
And how was it delivered to the business?
It was delivered in person by M. Davis, dated 5/4/22.
Did M. Davis work in your office?
Yes.
Okay. Moving to page 2, there are 2 code violation notices on page 2 of Exhibit B, both dated June 20th, 2022. Once again, are you familiar with these notices?
Yes, I am.
What were these notices issued for?
Tobacco sale without ID and tobacco sale to a minor by M. Davis, 7/19/22, which was done in person.
Okay, indicating the last part, how they were served to the business?
Yes.
Okay. And then the last page of City Exhibit B is once again a code violation notice dated June 10th, 2023. Are you familiar with this notice?
Yes, I am.
What was this notice issued for?
Tobacco sale without ID.
And how was it delivered to the business?
It was delivered in person by M. Davis, June 28th, 2020.
Before issuing the denial letter in City Exhibit A, did you check whether any of these notices were either administratively appealed or paid?
Yes, I did.
What would the effect of payment be for any of these tickets under the code?
I'm sorry, say that again.
Well, does the Philadelphia Code provide how these tickets should be considered if they are paid?
Oh, it's admission of guilt.
Okay. Moving to City Exhibit C. And I understand that it is small, so I am zooming in now so that it can be viewed. Is City Exhibit C a printout of the record of the outcomes of payments and administrative appeals?
Yes, it is.
Okay. Can you indicate whether any of, and do these correspond to the code violation notices that you just described for this business?
Yes, it does.
Okay. Can you please tell us whether any of these were either paid or administratively appealed?
All of them were paid without an appeal.
Okay. Can you tell us what date all of them were paid?
The first three was paid on 11/13/2023. And the last one was May 24th, 2022.
And as you indicated, under the Philadelphia Code, that constitutes an admission of that the notices were correctly issued.
That's correct.
Okay. Does it matter who makes the payment?
No, it doesn't.
Okay. I am zooming out and scrolling to City Exhibit D. Once again, just by reference, are these the tobacco regulations adopted by the
object to
City
this.
of Philadelphia that you enforce?
Yes, it is.
Okay. And as a result of your review of the records, this business has 3 separate instances of violations. Is the health department authorized under code to issue a renewal permit?
No, they cannot issue a renewal permit when there's 3 violations in 2 years.
Thank you. I have no further questions.
Ms. Wilkins, can we go back to the notice of code violation?
Are you asking me to share my screen for that? Mr.
Would
Lee?
you, please?
I assume that you're done, and Mr. Levy, you're now proceeding with cross-examination. Is that
Yes.
correct?
I might be able to share my screen. I'm not sure if I can do that, but
I guess your answer to my question is yes?
yes, Mr. Chairman.
Yes, I was done questioning Ms. Wilkins.
I guess my first question, Mrs. Wilkins, is what form did the payments come in? How were the payments tendered?
Objection, relevance.
My client's going to testify he never paid anything. So I'd like to know how Ms. Wilkins knows the payments were made. What confirmation does she get?
Well, again, these are administrative hearings.
Yeah.
I'll overrule the objection and see what, it may or may not be relevant, but I'll let you proceed with the question.
On the tickets that were displayed by Ms. Reinhardt and you earlier, the address of 3200 Hackenbury Road.
Well, wait, will you ask the question?
I'm asking Ms. Wilkins, where did she get this address, 3200 Hackenbury Road, Irving, Texas?
That was on the tax record. At the
Again,
time that the tickets were issued.
would it surprise you if the violation notices were sent there?
Well, I put this label on there and then my copy is sent over to the code unit, and the code unit
Right.
determines where the tickets should be sent. If that address is incorrect, they may have a more updated address. They can send it to whatever address they have on file.
So the point is that if you look at Exhibit B, I believe it is, the violation notice, and I could share my screen if you'd like. Oh, you can't do it. Okay.
Exhibit B is in front of us, Mr. Levy.
All right. Then do you have an actual City of Philadelphia notice of code violation form? It looks like this.
I can't see that. You may want to expand that.
This is essentially a City of Philadelphia.
Well, Mr. Levy, we can't hear you when the paper's in front of your mouth.
Can I share my screen, please?
Sure.
All right, let's try that.
Well, wait, this is cross-examination.
I know.
Well, whatever your screen is.
All right,
your
so let me ask you-
cross-examination is of documents that were presented by the city.
I'll limit the scope, Ms. Reinhardt. Do you have any way of knowing whether the payments came from Irvine, Texas, or from Philadelphia?
I do not know.
So you don't know. I granted, Ms. Reinhardt made the point of saying it doesn't matter. It's no relevance who paid it. But my point is, if these tickets were inadvertently sent down to Irvine, Texas, to 7-Eleven, and they paid them, is that what you want to hold my client responsible for? Because my client wanted to appeal those.
Objection.
I'll sustain that objection. You asked the you're factually asking where the payments came from. I believe your question has been answered, that Ms. Wilkins doesn't know where they came from. They were paid. That's what the record.
Was the notice of violation sent to Texas?
Well, the violations, according to the testimony of Ms. Wilkins, were also delivered to the store as
I
well.
understand that. I heard that. But my question is, were the violations also mailed to Texas?
And the answer was given, yes. I believe, Ms. Wilkins, did you answer that question?
As I stated, when my copy of the ticket goes down, I hand deliver them to the code unit here in the city of Philadelphia. When they process it, they mail it to whatever address is on file. If that address, they send it there. If they have a more updated address, they can send it to whatever address they have on file at the time they're processing it. The tickets were served individually, directly to the business at the time that I am responsible for it. I don't mail any ticket. I do not mail any ticket.
But they may have been sent to Texas, right?
Perhaps. I mean, I can't speak to that.
I think the question's been answered, Mr. Levy.
Very good. I'll call Mr. Shaw now, Mr. Chairman will allow.
Well, first of all, Ms. Reinhardt, do you have any redirect?
No redirect. Thank you.
I didn't think so.
Very good. Mr. Levy.
Mr. Shaw, tell the people your name.
My name is Anwar Shah.
And do you run Three Brothers?
Yes, I do run Three Brother Convenience Corporation.
The tickets in the May 30th letter, 2024. Did you receive those in 2022 and 2023?
No.
Did you pay them in 2022 or 2023?
No.
You know, Mr. Levy, all of a sudden, your image on our screen and that of Mr. Shaw has gone dark.
It's the limits.
We can hear you, but we don't really see you.
I don't know why it is.
Okay, that's better.
So I'll start over. Did you receive the tickets listed in this violation letter of May 30th, 2024?
No.
Where did you get this letter from? How did you learn about these violations? I'm asking you how you learned about these violations.
They sent me by Texas sent me those.
I'm sorry, we didn't hear the answer.
How did you get the violations? Notice the violations.
By email, by email.
From?
Texas.
And who in Texas sent them to you?
The market manager.
From 7-Eleven?
Yes.
And did he explain how he got them?
No.
Did he tell you when he got them?
No.
Did he tell you
Mr.
anything
Chair,
about
Mr. Chair,
tickets?
can I break in here a minute? Who is Mr. Shaw?
He's the owner of Three Brothers, the store.
He's in charge of Three Brothers, and he has no connection to Texas?
No, it's a Philadelphia company.
Mr. Washington, the store is a 7-Eleven convenience store, and I believe the violations were sent to based on what I'm hearing, they were mailed. They were also hand delivered, but they were mailed to corporate offices for the franchisor, which is 7-Eleven.
Mr. Chair, can we have a little breakout for a minute, please?
Could you, before you continue with your questions, we'd like to go into executive session. Could you hold on?
Chair.
All right, Mr. Levy, we appreciate the questions you're asking about delivery and who made payment and so on. And I believe we understand the issue. Do you have any additional questions for your witness to present? You're muted, Mr. Levy. You're muted.
Thank you. After Ms. Reinhardt has a chance to cross-examine Mr. Shaw, I'd like an opportunity to question Ms. Wilkins one more time briefly.
Okay, are you done with Mr. Shaw at the moment?
I am.
Ms. Reinhardt, do you have any questions for Mr. Shaw? You don't have to.
No questions at this time. Thank you.
Very good. With your, Ms. Wilkins has already been examined and had cross-examination, but if you don't object, Ms. Wilkins, would you be available for a further question from Mr. Levy?
Yes, I'm here.
I'd like to try to solve the question about how you got the address in Texas, and I think I might have inadvertently found the answer to it. Can we look at the ticket
It's
issue?
relevant, Mr. Levy.
It is relevant. I'll explain. Can we look at the ticket dated 6/10/23? That's ticket 233-5.
Are you asking me to pull that up?
Yes. If you'd be so kind.
I object to relevance here. I don't. think that-
I promise you, if you just give me, I have one question.
We'll let the matter, we'll let him proceed.
Which ticket was it that you?
233-5, the one issued June 10th, 23.
Mr. Chair, I have a 16/23. Okay.
On the second line, Ms. Wilkins, under the date, do you see where it says the word 7-Eleven store in script?
I'm sorry, where you want me to look, sir?
On the second line, under code violation notice, under the violation number, the word is written 7-Eleven store. You see that?
Oh, 40134A, yeah, I see.
Right. Do you see what the store number is there?
Yeah, I see, I mean, you mean between what's on the label, what's on the top of the ticket?
134 is the store number, is that correct?
That was what the person wrote, yeah.
But that's the store at 7965 Veree Road, right?
As understanding, that's what my staff wrote at the time.
So would you agree that the label says a totally different store number?
Yes, but that store number was given on the tax record at the time that it was.
Right. Isn't it possible that that store number also involved 3200 Hackenberry Road, Irvine, Texas, and the number up on top involved Veree Road?
Objection, call for speculation.
I don't
agree. I agree. There's no basis made for that comment. Objection sustained.
I have nothing further.
Very good. Do you have any closing argument?
Yes. You sent the tickets to the wrong place, and therefore my client never had an opportunity to challenge them. And we look forward to some forum where we will be able to challenge them. Thank you.
Ms. Reinhardt, do you have a closing argument?
I do briefly, thank you. The testimony has shown that the health department delivered these tickets to the store in person. That documentation of being delivered in person is supported by the notes at the bottom of each of the code violation notices, as pointed out by Ms. Wilkins during her testimony here. As a result, we are asking for city affirmed because the record reflects that there were at least three violations of separate incidents of selling to minors or sale without ID within a 2-year period for which the health department is not permitted to renew a tobacco retailer permit. Thank you.
Very good. We'll ask the panel to vote. My vote is city affirmed.
City affirmed.
City affirmed.
City affirmed.
All right, the decision in case number 9, HA 2024-002-747-7965 Veree Road, Three Brothers Convenience, Inc. is city affirmed unanimously. Thank you, Mr. Levy. Thank you, Ms. Reinhardt.
Thank you.
Next, Mr. Wade.
However, I have, Mr. Begelman was in a.
I'm not hearing you, Mr. Wade.
I have, next up is case 14. However, Mr. Begelman was in a breakout room with case 15, Mr. Ashton. I don't know if there was a continuance request or if there was. Mr. Begelman.
Yes, Mr. Ashton for case 15 has requested a continuance. He does not expect to be here this afternoon, has obligations with his family and his children. Because this is a first listing, the city does not oppose that request.
All right, we will mark the case continued, and it could be noted that that the objection of the timeliness of the appeal is not a matter that we're not supporting that argument.
Noted.
So we'll hear the case when it's presented next time, if not resolved. All right?
Mr. Begelman, he's not coming out of the breakout room. I don't know why, but
okay.
If you want to let him know that the continuance was granted. Are you on case 14?
I am.
All right, I'll call case 14 and then I'll go in and let him know.
Okay, great.
All right. This is case 14, hearing appeal ending 2434 2939 North 22nd Street, Isaiah Morgan.
Mr. Morgan, are you still with us?
Yes, sir. I'm still here.
Very good. Would you raise your right hand, please? Do you swear or affirm the testimony you give today will be the whole truth and nothing but the truth?
Yes, I do.
Very
Excuse me,
good.
Mr. Chair.
Yes.
Mr. Ashton is on the screen. Can we notify him that his case has been continued?
Yes.
Is that the one Mr. Begelman was speaking in reference to?
Yes.
Mr. Ashton, can you unmute yourself and just confirm, did you hear that we've agreed to continue your case?
Yes, I did hear.
Okay, very good. You're welcome to stay on and watch or observe what happens. These are open hearings to the public.
Thank you.
All right, it'll be continued and you'll get a new notice, another notice of the new hearing date. All right?
Yes, thank you.
Very good. Who's Mr. Begelman? You've got number 14, correct?
Yes. The city's witness is Supervisor Ken Paralak from the Department of License and Inspections. I don't see him on the participant list. He was here and I've been speaking to him. I don't know if I'm just missing his name or if he's no longer listed.
I'll look on my screen. Mr. Wade, do you have a?
Who are we looking for?
Ken Paralak.
He is in a breakout room with Christopher Johnson right now. If you give me a moment, I'll get him.
Okay, great.
He's coming in now.
I'm here.
Okay. Let me see if I can find you. Okay, Inspector Paralak.
Yes.
Could you raise your right hand, please? Do you swear or affirm the testimony you're going to give today will be the whole truth and nothing but the truth?
I do.
Very good. Mr. Begelman.
Yes. Good afternoon, Mr. Paralak. Can you please state your name and position for the record?
My name is Kenneth Paralak. I am the interim manager for the Audits and Investigation Unit.
Great. And what are some of your responsibilities as manager of the Audits and Inspections Unit?
To oversee the daily activities of all the supervisors and inspectors of the unit. To testify for Blair hearings also.
With the board's permission, I'd like to share my screen, and show the exhibits I sent to the board yesterday.
Yes, you have my permission.
Can you see my screen?
Yes.
Try to zoom in.
And I just want to confirm as we proceed, Mr. Bagelman, the violation notices were issued to Isaiah Morgan and to Loyalty General Contractors, or I guess addressed to Loyalty General Contractors LLC at 2519 Germantown Avenue. And you've indicated that Mr. Morgan is the holder of a contractor's license. Is that correct?
Correct. So I'm going to show Paralak what I previously marked as Exhibit A. Can you see my screen and please identify this document for the board?
Yes, this is a licensing violation. Notice.
And who is this licensing violation notice issued to?
Can you blow that up a little bit? It's very small on the screen. Isaiah Morgan.
And what license was cited?
What is their contractor's license number?
Yeah.
Is 054582.
And does Mr. Isaiah Morgan hold that license, that contractor's license?
Yes.
Can you identify the violations issued in this violation notice?
Required subcontractor list not uploaded, and failure to respond to it audit email.
Is there language from the Philadelphia Code for each of those violations listed on this notice?
Yes. So for the required subcontractor list, from the initial start of inspection, all subcontractors have to be uploaded within 3 days of start of work. And then I'm sorry, go ahead.
Yeah, proceed.
And then for the failure to respond to the audit email, contractors shall cooperate in any audit or investigation by the department or other law enforcement agency into the activities at any job site at which the contractor has performed work, and shall prompt, accurate, and complete response to inquiries by the department and other appropriate agencies.
Thank you. I'm going to move to what I previously identified or previously marked as City Exhibit B. Can you identify this document for the board?
That is a notice of a commercial building permit.
And what is the permit number listed here?
CP 2023-001095.
What was the date this permit was issued?
5/22/2023.
Okay, and who is the contractor listed on this permit?
Looks like Isaiah Morgan. I'm sorry, the screen's very small.
I apologize. I'll zoom in again. What is the address of the location of work for this commercial building permit?
2939 North 22nd Street.
Great. And what type of work is authorized by this commercial building permit?
Scroll down a little. It's a approved scope of work for level 2 alterations with partial change of occupancy classification to the existing 2-family above first floor, separate fit out and use registration permits required for the commercial space. Building is non-sprinklered, separate permits required for MEP, mechanical, electrical, plumbing work. Amendment to the first floor commercial space, fire rated ceiling.
I'm going to scroll down to the second page of this permit. Actually, the third page of the permit. Was this permit issued subject to any conditions?
Yes.
And are those conditions listed in on this commercial building permit notice?
Yes.
Can you read those conditions into the record?
Yes. This permit This permit's, thank you. This permit's responsible contractor must keep the permit updated on Eclipse with the name of each subcontractor that has performed any work described in the permit's approved scope of work. This is required within 3 days of business start of any work. Failure to keep the permit updated in Eclipse may result in the department issuing a license violation of 9-10048A3 to the responsible contractor. The violation will result in a fine of $2,000 for instructions on associating the subcontractor with a permit and other Eclipse guidance. See our Eclipse help page at phil.gov/li/Eclipse.
Now, those conditions that you just read refer to a responsible contractor. The contractor that was named in the commercial building permit, is that the responsible contractor for this permit?
Correct.
Thank you. I am going to scroll to what I previously had marked as City Exhibit C. Can you identify this document for the board?
That is a audit email from Laura William Michael.
Is he an employee of the Department of License and Inspections?
Yes.
And who was this email sent to?
The email was sent to Isaiah Morgan 32@yahoo.com.
Have you reviewed, is Isaiah Morgan 32@yahoo.com, is that the email address that the department has on file for Isaiah Morgan, the responsible contractor for that building permit?
Yes.
And what is this email about?
That email is requesting a detailed list of every subcontractor that is working on site at the time of the request, down from drywall to carpet layers, painters, anybody who's working on site. We want to know who the contractor is, what their license number is, and if the work. So that detailed list, it'll have all the trades on there. If nobody started work, you'll say work has not started. Or if you're doing it on your own, you'll say no sub needed.
But the recipient of this email, the responsible contractor, they have an obligation to respond to this email from the department.
Yes, they do.
Regardless of whether they have any contractors or they haven't started yet, they have to reply to this email.
Correct.
Great. And what was the date this email was sent?
April 26, 2024.
Did this email provide a date that a response was due by?
7 days.
7 days.
From the date of the email sent.
Is it listed May 3rd, 2024 in this email?
Yes.
Did the department receive any response to this email from Isaiah Morgan?
No, we did not.
I'm going to scroll to what I previously marked as City Exhibit D. Can you identify this City Exhibit D for just state our series of pictures? Can you identify what this picture is displaying here?
It's the first front facade of the building.
What date was this picture taken?
April 26, 2024.
Now, are these pictures stored in the city's Eclipse system?
Yes, they are.
Or is the city's Eclipse system used in the course of the Department of License and Inspection business?
Yes.
Now, based on this picture, what do you observe in this picture of the space on North 22nd Street?
It's a mixed-use building.
Is there a sign on top of this building?
Yes.
I'm going to zoom in. Can you identify what that sign says?
Loyalty General Contracting.
And
2519 Germantown Ave.
That was the name of Mr. Isaiah Morgan's LLC, correct?
Yes.
That was listed on the commercial permit we saw previously?
Yes.
Let's scroll down to the next image, or two images. Is this the inside? Is this picture showing the inside of that space on North 22nd Street?
Yes.
Scroll to the next picture. Is this also in the interior of the property on North 22nd Street?
Yes.
What did the department observe on the interior of the building?
Interior,
On April 26, 2024.
so there's wood framing installed, looks like PEX PVC's installed, electrical wiring installed, and also ductwork.
Scroll to the next picture. Is there more interior framing shown in this picture?
Yes.
Scroll down more. This picture also show that work is being performed inside the building on North 22nd Street.
Yes.
And finally, one more. Is this additional interior framing being performed in the building on North 22nd Street?
Yes.
Did the department determine that work had started on this project by April 26, 2024?
Yes.
And that was the same date the email was sent that we saw before asking for the list of subcontractors?
Yes.
I'm gonna scroll through is this another picture showing that interior framing and work is being performed inside the building?
Correct. Yes.
And same thing with this next image. Is that electrical work being shown as performed inside the building?
Yes. Electrical, plumbing, the red and blues, PEX PVC water pipe.
Show you another picture. What does this image depict?
That is framing in the background and an electrical box, electrical panel.
Great. Just in conclusion, Mr. Paralak, you stated previously that there was no response to the audit email sent to Isaiah Morgan. Is that correct?
That is correct.
And was there a list of subcontractors provided to the department within 7 days of that audit email?
The audit email was not sent back to us now.
Okay. I have no further questions for Mr. Paralak.
Mr. Morgan? This is your opportunity at this point, not to tell your version of what happened, but to ask Ms. Inspector or Supervisor, Acting Supervisor Paralak, questions regarding the statements that he's made, his testimony. You'll have an opportunity to provide your explanation of why you think the city didn't do things correctly or whatever it is that you're challenging. But the question is, do you have any questions of who was, I guess, inspector or the chief inspector regarding the statements he's made with respect to all of the exhibits that were presented?
Yes. Do you have the date that was them pictures you were saying took in on the 26th, you were saying? Of April? That was the question.
The pictures are time stamped.
No, I was asking just what, do you know the date that they was taken?
Yeah, there's a timestamp on the photo. We could provide the photo back to you with the timestamp. I believe it was the 26th.
Yeah, that's all I'm asking. Yeah.
Just a moment. Mr. Begelman's putting the pictures back up. Timestamp on the pictures that I see is April 26th at 8:43 a.m. and 18 seconds. Wow.
Okay. Yes. So questions pertaining to the pictures is the actual pictures of the building. So I'm not in contest of the pictures of the building. So as far as the questions to the pictures itself, no, I don't have a question to the pictures itself.
Well, if you have questions, again, that relates to something the inspector supervisor has said, please ask your questions.
Okay, so in regards to the work that has been performed on there, so on February 29th, the architect and the engineer that was on the permit, they had an amendment placed on the permit. So all work had actually stopped since February 29th, and the actual permit for the amendment came back on, it came It came back on March 20th and it was issued on March 26th. So before that, all the contractors that has performed any work, including myself, was uploaded on the first initial permit. When the permit got amended, they issued us a new permit. And once it got amended on the 26th and was issued on the 26th, first I was under the impression that all the attached contractors, including myself, transferred over from the initial building permit because there's a electrical permit attached.
Well,
to
wait, Mr. Morgan, you're in a sense presenting argument.
Oh, no.
I didn't want to let you go forward, but your question might have been, and you're suggesting that there was an amended permit.
Yes, sir.
That hasn't been testified to. So unless you want to ask a direct question about whether, well, I'll ask the question, Mr. Paralack, do you have a record of an amendment to the building permit?
I'm looking on Eclipse right now, and there's no amendment. There's one permit, CP 2023-001095.
Which is the one that was referenced at the beginning. Is that correct?
Correct.
Mr. Chair, may I ask a question?
Go ahead, Mr. Washington.
From your appeal, you put on here that all the permits were submitted by Expediter, and not by you, right?
Let's go back before you ask that question. That would be part of whatever Mr. Morgan is going to present, because right now we're just dealing with the testimony of Supervisor Paralack, correct? So we can get to those questions when Mr. Morgan's case is presented in chief. All right, Mr. Washington, do you understand?
Yes, sir. Yes, sir.
All right, so again, do you have a question regarding turn off? Okay, do you have a question regarding the testimony of Mr. Paralack? Anything that he has said?
I mean, in regard to that, that was basically my question, my contest to it, I have the proof.
Well, wait again. Do you have questions for him?
I directed for that since it was only pictures presented. I don't have a direct question towards the pictures itself.
All right, the pictures were taken on a date in April, but that work could have been completed in February. Is that what you're contending, and the project was stopped for a while?
Yes, sir. The project had been stopped.
Okay.
Yes, sir.
All right. Mr. I guess, would you want to close your screen down, Mr. Bagelman?
Sure.
Do you want to have any redirect to Mr. Paralack? Supervisor Paralack?
Manager
Paralack.
Manager.
No, I have no redirect for Manager Paralack.
All right. So, Mr. Morgan, if you're contending that there were amendments or an amended permit, and I don't know whether we should, well, let's hear your contention, because maybe there's something that could be discussed between the inspector and Mr. Bagelman, and maybe there's a record here that needs to be verified or checked out before we try to resolve this case. I don't know.
We have some records. Maybe if I could share my screen.
Sure.
Updated amendments.
All right, now did you present anything you're sharing with us? Did you send that into the board?
Actually, no, sir. I don't know how to do that. I did this like my first time ever in this situation, so I'm kind of learning as I go. It's just I have it on my computer and I have things written down, and in the Eclipse system, there's the amended permit from the new date.
Well,
it was issued on the 26th, so I do have.
If that's on your screen, I have no objection to your, unless Mr. Bagelman wants to object, presenting that for us to review.
No objection.
Okay, my wife is helping me out. 1 second. Can you see my screen?
Not yet, hold on.
Oh. He sent it in the top of the email too. So it's the plans, amended plans and everything is in there.
From the architect?
Yeah. Go to the email or share the email screen.
Able to share the screen, Mr. Wade? Is this something he can do from his home? I'm not.
Yeah, no, it's in my go to Loyalty General Contract.
Does he need any authorization to be able to do it, or is he okay to share a screen?
No,
if
he can share.
You want to show the amended plan?
Yeah,
Okay, 1 second.
I'm trying to get it up right now, sorry.
All right, we understand, and we understand you have help from perhaps a very able assistant.
Hello. Okay, are you able to see the screen?
Yes.
So if you see the stamp plans right there, these plans, the architect, Richard Navis, had issued an amendment on February 29th to amend the plans for the fire blocking and installation. And the actual code for the first floor, he wanted to adjust some things on that. And from that date, from February 29th, it got approved on March 20th.
Well, wait a second. You're saying, is that the stamp that's shown on the lower left of this?
Yes, when they came back, the stamped approved plans from the new amended plans. So
can you wait? Let us see that.
I'm trying to open it up.
She's trying to open
it up as I can.
I understand. I would be challenged trying to do this, but if that's a stamp approval from L&I, let us see it more clearly.
I'm trying to get it. There you go, right there. City of Philadelphia Department of License Inspection, right there. And that's on 3/20/24. And I wasn't performing no work in the building. I did follow up with all the inspections. The first one I set was a in-wall inspection on 4/5.
You can tell them the name.
And I can
hold on. You know, your wife is she can help you with the mechanics of this,
okay.
But she's not a witness and can't be speaking on the record. Okay.
I apologize.
But you can give her instructions on what documents that you want us to look at. So you have a set of approved plans that the city approved, but that doesn't necessarily show that you've responded or provided them with a list of all the subcontractors on the job. Right. Unless you're saying that the original plans had a list of subcontractors.
So yes, the original plans had everything connected to it. And then I did go back into the Eclipse system once I was privy of everything, and physically I can pull that up too and show you the Eclipse system if that's necessary.
Please.
Okay.
This is your case to present and show us why you were in compliance.
So here's all the subcontractors that's connected to the actual building permit. And everybody, as far as with the electric, everybody does their own inspections and stuff like that. So for the electrical, you got the Costello Energy. For plumbing, you got Gary Thompson. For the fire alarm, you had JR Electric. And for the HVAC was Silver's Construction. All their license, and everything is connected to their permit. And all the inspections were actually approved and passed up until our final at this point. And I have the documents in
Well,
that.
wait,
that
slow down. What, I can see the list of the subcontractors. What date are you saying that this is what date is it? I see a May 22, 2023. Is that the?
Yes, sir. That's the, so the application issue date, it's the application date. I don't, let's say the building permit. So I don't know why it says May 22nd.
All right, but what are you saying is the date that these contractors, these subcontractors, list of information was within at the city? What date are you contending?
They always been there.
So that you're saying the list of contractors didn't change from the original application date?
No, so an original is only the general building first, but everybody that came on as their phases, no contractors has changed. So once I was done with physically framing and things like that, and then say the electrical came, that's the same contractor from the start of the electric, same contractor from the start of the plumbing, same contractor from the start of HVAC. Everybody that pulled their own permits has been the only contractors working on that scope of work. And I'm the master carpenter myself.
Okay.
The city's not asking for child permits to be listed.
Well, wait a second. In the you're the witness for Mr. Bagelman. Mr. Morgan is presenting his case.
I'm sorry.
So I'm trying to make sure that we get as much information as we can. If there's an issue that's from the technical standpoint about compliance with the requirements of the city, then Mr. Bagelman can come back and question you about that or talk with you and then present that to us. I think what Mr. Morgan is trying to show us is that he believes he had provided this subcontractors list to the city, at least when he first was issued a permit. And if I understand it, that there was an amendment to the permit, but that didn't change, as far as he was concerned, the information with respect to his subcontractors.
And should I show the amendment? If there's something else with it, should I show the amendment?
Please.
One second. What's the address? 29.
I don't know if you have the ability, but what would be nice is if when you're done with this, you make copies of all these documents that you're showing us, scan them in and send them to the board.
Okay. It's moving a little slow right now. I'm sorry.
Well,
No, not. It was the. Mm-mm. Seen it yesterday. Can we have a second while I look for it?
well, I think we've seen enough at this point. and we'll accept the representation that the amended plan, a permit was issued on the amended plan. Then we go back to the questions or the issues, Mr. Bagelman's case, which is that there was a permit issued and that there were requirements. Is there anything further you want to say, Mr. Morgan?
I'm trying to pull it up. I do. So you saying that? Not sharing the screen too.
I did.
All right,
Yeah,
if
Mr. Chair,
you've explained your case.
I haven't said.
That's my question.
I'm
All
sorry.
right. Wait for let's hear Mr. Washington's question.
I'm still going to ask back again, Mr. Morgan. You made a statement on your appeal that the permits were submitted by an expediter. How do you know when they submitted it and whether they submitted all the right documents, since you didn't do it yourself?
Because that's the emails that I'm pulling up. It's the actual architect that actually is the expediter on it. The architect, he drew everything up and he actually submitted everything for us.
Okay, he might have drew everything up, but I'm asking about your the folks you had, your subcontractor. Your architect would not have hired the subcontractors, would he?
No,
That's
I'm not.
when you said you was running that. So
No,
if you hired the subcontractors, did you submit the information, the list that they're asking for? Right now, the city is asking you for a subcontractor list not uploaded, and you had a failure to respond to an email audit. And since you are in charge, I want to ask you, why wasn't them things done?
I did upload it, sir. It is uploaded on there. I just showed in the Eclipse system that it's on there. All the same contractors, the same contractors.
And when you submitted your updated list, you updated those names. Not that you assumed that they was updated automatically. You updated those names, correct?
Yes, the existing names. Yes, I updated the names. Yes, the name that it was. Once I was privy that everything came back with the amendment, and I went back into the system just to double check, and everything was updated.
All right, now what was the email audit that they're charging with failure to respond?
You said, when was it?
What was it? Because I'm from what I'm reading, the contractors that you put on your listing never respond to the department.
Well,
Yeah, they were saying,
Mr. Washington, I don't think the contractors the subcontractors had a duty here. It was Mr. Morgan's duty to provide this information to the city. And the question is, did he and when did he do it? And I think Mr. Morgan is saying that he did it at least initially. And are you testifying today that after the amended permit was issued, you did it again?
yes.
And the question is, I guess, do you have a record that shows you resubmitted that? I know you showed us a list, but I couldn't see a confirmation date. I did see that date, May the 23rd, which would suggest that was the list that was with the city on that date. Is that
Yes.
what you're saying?
May 2023, yes.
Okay, all right.
Thank you, Mr. Chair.
Is that being clarified adequately, Mr.
Yes, sir.
Washington?
Yes, sir.
All right, Mr. Bagelman, do you have questions of Mr. Morgan?
A few, yes.
I'm sorry, Mr. Bigman. I don't want to be rude, but I'm just making it clear, right? My my computer is on, it's charged. My cord, if for some reason the computer cuts off, it's not me. I will try to get back onto the link, but I just want to make it clear. I didn't mean to cut you off. I apologize.
We understand.
It'll be good though.
Hi, Mr. Morgan. When you shared your screen previously, the email account that was pulled up, was that Isaiah Morgan 32@yahoo.com?
Yes.
And one of the emails you pulled up was a Department of License and Inspections audit for permit number CP-2023-001095.
Yes,
Is that
sir.
correct?
Yes, sir.
Okay. You stated during your testimony that you stated a couple things. You first stated that there was some work performed prior to amendment and then work was stopped while you amended the permit. Is that correct?
Yes, sir.
And you also, I believe I heard you specify a specific date of April 5th that work was being performed. Does that sound familiar?
Not April 5th. No, May 5th.
May 5th. Okay. But just to clarify, there was work being performed prior to April and then work again
sorry.
performed after April. Is that correct?
That wasn't work. Yeah, that was an inspection date to be able to start working again. That's what that 4 or 5 was for. So it wasn't physically work. It was an inspection date. That was the first inspection date that I was ready at.
Okay. But there was work performed prior to that April 5th date.
Prior meaning before 2/29. Because once the amendment came in, no, I wasn't physically doing any work in the building.
Just to simplify things, there was work being performed. There had been work performed inside the building prior to April 26, 2024.
Yes, prior to, yeah.
Okay. On April 2026, 2024, there was an email sent to Isaiah Morgan 32 at yahoo.com from the Department of License and Inspections. Is that correct?
Yes.
And that was asking for a list of subcontractors to be submitted via the Eclipse system. Is that correct?
Yes.
And that information was due by May 3rd, 2024, right?
Can I speak to that now?
Just to answer the questions, yes or no.
From reading it yesterday, yes, it does say that. But
Okay, thank you. Did you respond to that email with a list of subcontractors?
No, I have not.
Thank you.
Yes. So can I say something to that?
No, my question was just a simple yes or no. I have no further questions for Mr. Morgan.
May I
I
say?
guess I have a question for Mr. Morgan. I think I'm trying to balance the technical requirements with his efforts to act in good faith with respect to the requirements of the department. So did you at some point provide a new list of subcontractors, whether or not was within the 7 days? Could you just answer that question? Or give us a reason why you did not provide that list?
So what happened was, and it was an error in my mistake and in the office. I'm actually using Loyalty General Contractors email now more. And I was basically asking the office and myself to transfer all the emails from Isaiah Morgan to Loyalty General Contractors because I don't actually use that email no more. So I didn't even get privy of the audit email until May 10th, and I responded by May 10th, which was still 7 days late. But by the time I realized it, and I got to by the time I realized what it was, everything was uploaded and addressed in the Eclipse system. So when I spoke with someone from L&I, and I don't have their specific name, it was just, okay, make sure that all the information of the contractors is uploaded in the system and enter an appeal, and then come in and explain that I didn't get a chance to get the email to respond. And then actually, being 100% honest, I didn't even find the audit email itself in my physical computer until last night. That's why it's at the top of everything, because I had my wife bring it from where it did come on the 26th, but I didn't see it in the actual computer in front of me until yesterday. So even if I could show that, that's why you see it at the top, because I did tell her bring everything to the top of the emails.
So you, if I may, Mr. Morgan, you actually on your end were doing an administrative changing of email addresses and information, which is, it's not the city's fault, but the fact is it got you confused and delayed in being responsive to these things. Is that fair to say?
Yes.
Because of your internal administrative actions?
Yes, I was paying more attention to the Eclipse. So I didn't really see it in the Eclipse system. And I didn't think to look in the Isaiah Morgan email because I'm literally in the
Fine. Fine. Let me ask one more question. Are you in compliance today?
Yes, sir.
All right. Mr. Bagelman, we've asked him some additional questions. Do you want to ask anything further, or do you have any redirect for Manager Paralak.
I would like a brief redirect of Manager Paralak, if that's okay.
Sure.
Thank you. Manager Paralak, when the Department of License and Inspections sends out an audit request form asking for information about subcontractors, does that go out with every project or only if the department does not have a list of subcontractors at the point the email is sent?
It's any job site that had an audit done on it. We request a detailed list of subcontractors. Even if there was 2 or 3 subcontractors listed on the commercial building permit, we still ask for a detailed list. You have to respond to that list.
When this email was sent in April 26, 2024, did the department have a list of subcontractors for this commercial building permit?
No. On June 6, 2024 was when the subcontractors were uploaded to the permit. There was 1, 2, 3, there was 4 contractors uploaded all on June 6, 2024.
On June 6th, but the department requested that information by May 3rd, 2024. Is that correct?
Correct.
And there was some testimony about when exactly work under this commercial building permit had started. Do you know when work started, based on your understanding of the case file and the various processes and inspections under the commercial building permit and your review of the case file? Do you have an understanding as to when work started under this commercial building permit?
I do. The initial inspection was passed on June 27th of 2023. Then there was another inspection for framing that was failed on February 2nd of 2024.
So we saw the email requesting that list of subcontractors by May 3rd, 2024. But in fact, there were a list of subcontractors owed to the department well before that. Is that correct?
Correct.
And if that's the code requires that list is provided within 3 days of starting work.
Correct. And we're not asking for the mechanical, the plumbing, the electrical. Those are they're their own contractors. They have their own permits. They're not required to be listed on the commercial building permit. The subcontractors that are required to be listed are the framers, the drywallers, the painters. All the contractors that do not have their own permits are required to be listed on the commercial building permit within 3 days of start of work. And if they haven't been selected within the 3 days, then you only list the ones that have been selected. And it's their responsibility to keep up to date with adding the contractors on as they start work.
Thank you. And I don't want to ask you for a legal conclusion, Manager Paralak, but based on your understanding of the Philadelphia Code and the requirements for contractors to a commercial building permit, is it a violation of the Philadelphia Code for failure to provide that list of subcontractors within 3 days of work?
It is.
And so if a contractor provides that list 1 year later, 6 months later, is it still a technical violation of the code for failure to provide that list of subcontractors on time?
It is.
Thank you. I have no further questions for Manager Paralak.
All right, so do you have a question? Because there's a question. Because there's been additional testimony for Manager Paralak. Do you have a question, Mr. Moore?
Manager Paralak actually just clarified something for me that perfectly made it clear for me. I am the carpenter. There would be no other sub added but me. I physically do the work myself. I'm a master carpenter. I frame, I do.
All right, so fine. That's not a question.
No, sir. No, sir. No question to that, but I do want.
All right, so it did.
I'm sorry, but yes, I don't have a question to him.
Okay, so let's do closing arguments, and then once we've heard your arguments, I'll ask for a brief administrative session, okay? This is your opportunity to sum up and explain why you don't think these why you made your appeal.
Okay, so understanding it clearly now, yes, I do all the work physically myself. I'm a master carpenter. I graduated at the top of my class from Orleans Tech. I do all of that. So far as the work, the framing, the anything with sheetrock, drywall, painting, I do all that. That's why it's me, it's my company. As far as with their mechanicals, everybody else I bring in to do their mechanicals because I don't have a license for electric. I don't have a license for none of the other mechanicals. But outside of the MEPs, I literally do everything. So my license is on there and I am the contractor that's uploaded. So if I'm supposed to upload my name again, then no. But one thing that I learned privy that I had to write no subs. I didn't know I had to write no subs if I was physically doing the work myself.
Okay, all right. I get it. Mr. Bagelman?
Yes, the city's going to request that this be this violation be affirmed. This is actually a very simple matter here. There was a commercial building permit issued with Isaiah Morgan listed as the responsible contractor. The permit made clear that a condition of the building permit is that the responsible contractor must keep the permit updated on Eclipse with the name of each subcontractor that has performed any of the work described in the permit's approved scope of work. There's also a requirement that the responsible contractor reply to any audits and emails sent from the department concerning the scope of work under the commercial building permit. Mr. Morgan admitted that his email address that the email was sent to is correct, admitted that that email was in his inbox, admitted that he did not respond to that email, admitted that he did not produce that list of subcontractors by the time the work had started. The evidence is clear that this was not done by May 3rd, 2024. In fact, it should have been done earlier when work had actually started. So I know Chairman Pincus referenced a technical violation versus good faith efforts to comply, but the licensing violation notice that was issued here is a technical violation. The Department of License and Inspections requires this information within a certain period of time of work starting, and especially within a certain period of time of that audit email being sent out. That did not occur here. There was no response to the audit email, and there was no list of subcontractors provided to the department until June 2024. So that may be a technical violation, but a technical violation is still a violation of the Philadelphia Code. Even if those subcontractors were uploaded at a later point, the fine still issues because of the failure to timely provide that information. And so for those reasons, request that the violations be affirmed. Thank you.
All right, we'll take a brief administrative break and be back at 4:10. I see Mr. Kelly. I just want to see him raise his hand that we are back on the record. We're back on the record. Before we proceed to vote, one of the members of the board had to leave at around 3:30. So you'll see that Mr. Tennant is no longer here. We are three members, myself, Mr. Washington, and Mr. Patton. And for purposes and as permitted by the ordinance, we are a panel and we can proceed to hear and vote on the matter as a panel. Mr. Wade, did you want to add something? Mr. Wade.
Oh, no, I'm sorry. I was speaking to
Okay, all
staff.
right. I saw you waving your hands, thinking you might want to say. So,
Sorry about
all
that.
right. So let us proceed with the vote. And Mr. Morgan, I just want to compliment you. You for a complicated kind of situation, you did a pretty good job for yourself with the help of your able assistant, trying to explain your position in the circumstances. But unfortunately, the circumstances are, did you comply with the requirements of the department? My vote is to affirm the city that the violations were properly issued. So that my vote is city affirmed. Mr. Washington?
City affirmed.
Appeal sustained.
City affirmed.
So the vote is 2-1. Two of us sustained the city. It was one vote. I'm sorry, two of us affirmed the city and one vote was sustaining the appeal. So you've lost your appeal. You'll get a letter informing you of what your appellant rights are, I do understand that in this particular matter, there are substantial fines that you could be subject to, or you will be subject to. There is a city tax review board that hears appeals on fines and penalties that are assessed by the city. So you may want to try, I can't tell you how that would proceed, but you may want to look into filing an appeal within no less than 30 days to the city tax review board on this determination. But the finding today is that the city's actions have been affirmed 2-1.
Can I ask a question?
Sir, go ahead.
Just from my understanding. So in the future, right? If just clarification, if I got
Wait, we're in the future. If you're talking about procedurally how to deal with
I'm
this.
talking about this situation, like, okay, so, and I'm speaking of the fine. One of the fines was $1,000 for not. I'm to the point, sir. That's all I'm asking. Be brief.
Mr. Morgan, if you have a question that does not concern this appeal, you can feel free to email me with that question. I can speak to the department and we can deal with this offline.
I could take your email too, but it does have something to do with this appeal. Yes. Can I take your email while I have you, sir?
I'll email you. Sure. It's Lee LEE.BEGELMAN @phila.gov.
NAN.
Yes, my name on the screen at phila.gov.
Okay, so the thing was, I'm the contractor.
All right, well, wait, so why don't you, at this point, we've rendered our decision. We have a whole bunch of other cases to consider. So, and we've given you pretty much a lot of time to present your case. So if you have any questions, Mr. Bagelman has agreed to be available to you. He knows this stuff and he should be able to answer any questions you may have. All right?
And I can email you, Mr. Bagelman?
Sure.
Thank you.
Thank you. Thank you. Have a good afternoon.
Brings us to case 17, hearing appeal ending 2771346 North 52nd Street, Curon Pierre.
Hey, hello, good afternoon.
This is Christopher Johnson for the city of Philadelphia.
Good afternoon, Mr. Johnson. Good afternoon, Mr. Pierre. Can we swear you in, Mr. Pierre? You want to?
I just wanted to ask, am I able to get a continuance for the case?
Well, you're able to get I mean, I guess you could if Mr. Johnson doesn't object.
I think the department wants to put the case on today. We've all waited for nearly 4 hours at this point, and I don't believe this is going to take as long as prior matter.
Yeah, I'm supposed to be at work in 15 minutes, man. I've been sitting here like.
Well, I'm sorry, we can't. Why do you want to continue the case?
Simply because I'm trying to get to work. I can't really be late. And he was gonna see about maybe reducing some of the fines. He said he was gonna email me about it, and I'm okay.
Well, you haven't been sworn in, so we don't want to hear we just want to determine whether or not we can continue the case or not. And you have an inspector here as well. Is that...
Inspector Slade and Manager Paralak are both here.
Give me a minute to have a short administrative session. All right. Give us a minute. We'll go. All right, Mr. Kelly, we're back on record. Mr. Pierre, we're going to grant your request for a continuance. I have to see you on the screen. There you are.
Right here.
All right. Please keep in mind that obviously you've seen today's proceedings. You know how long they can take. I'm feeling badly that we've kept an inspector here for 2 hours, 3 hours.
Yeah, I apologize. I'm sorry.
All right. So you have to be prepared that when your case is listed, it could be all afternoon. And even though Mr. Johnson says it's not going to take long, we'll give you the request that you've honored, that you've asked.
Yeah, this is my first time ever doing this. I honestly thought that when you signed on at the 12:30, it was like your time. I'm not sure. I
We
apologize.
understand, and I explained it at the beginning that there's no guarantees.
Yeah.
However, now you'll know for next time, and perhaps you can try to find a way to resolve this matter between now and whenever it's relisted. Okay?
Okay. Are you gonna email me, Chris?
However you receive the
I'll send you an
commitment.
email.
Okay.
And change the battery in your fire.
Yeah, in my fire. All right.
Thank you. Thank you, Mr. Slay, Inspector, and thank you, Mr. Johnson, for your cooperation.
Thank you guys for everything.
Okay,
That brings us to case 40, hearing appeal ending 1325, 8823 Wayne Avenue, Vernon Lucas.
Mr. Vance, are you still here? There I see his name.
Yes, I am.
All right, so this is case number 40, Vernon Lucas. Just for the sake of everyone on the panel who's involved, Mr. Vance and I have known each other for too many years for me to remember. We both had a lot more, and different colored hair when we first met. So we've known each other for a while, and we've been neighbors for most of that time as well. So you have, does the city have a witness to present?
Yes, there is a preliminary issue that I was hoping to address with the board, though, if I may.
Sure.
So I think that this issue is important to how we proceed today. As I believe the board is aware, at prior hearings, Mr. Lucas had contended that the licensing violations that originate from Animus, and has offered exhibits and testimony that he alleges supports that allegation. The city obviously disputes that assertion that Animus is the origin of any of these violations. And I'm not saying that Mr. Lucas is prohibited from making those statements or lodging those claims. But given what has occurred at past hearings, I just want to raise, is the issue of Animus relevant to whether, as is the case here, a kitchen countertop had the required GFCI protection? From the city's perspective, the answer to that question is simply no. Even if Mr. Lucas is correct about an inspector's animus towards him, which I'm not admitting, it does not and cannot change whether an outlet has GFCI protection and a violation exists. And I will try and get to the point here. While the board often takes a broad view of what is admissible in these hearings, I believe that in this instance, in delving into the animus.
Have a great night.
Thank you.
Careful.
Hold on a moment. Okay, go ahead. Mr. Slade, you're on. You should be muted unless you're testifying. Okay, very good. I'm sorry, Mr. Rulo.
So, while the board often takes a broad view of what is admissible in these hearings, I believe that in this instance, delving into this animus issue can respectfully cause these hearings to go off the tracks into an extensive analysis of something that can't assist the board in determining whether, like I said, GFCI protection is present in an outlet. So this, again, is not an effort by me or my client to deprive Mr. Lucas of any rights. He, like everyone, has the right to make statements and claims, but this just isn't the forum for resolving that and finding a resolution there. And again, I know I've droned on, but I'm asking the board for the smoothing out this proceedings as a preliminary matter to rule and exclude testimony and evidence concerning this topic of animus so that we can really focus in on that issue of whether or not a violation does or does not exist.
I appreciate your calling that to our attention. And as a matter of fact, in executive session, to be candid, we did, or I recalled the prior hearing and the fact that this was an issue and were issues that were raised by Mr. Vance at that hearing. And while that certainly may have some relevance to what's happened. It's not factually relevant, as you're pointing out, to the actions or the observations that were made. So we're going to try to limit the presentation of testimony to the requirements of the city code. And if in fact there's issues that involve the relationship that were involved or personal actions that were involved, there may be a different forum than this board to raise those issues. And I don't know that this is the place where those matters are put on record either, because again, we're here to hear whether or not the violations that were issued should be affirmed or not. So while I'm appreciative and mindful of what's been described or alluded to, I don't believe it's appropriate for us to get into those issues today in front of this board. So I'm agreeing with you, Mr. Rulo. Mr. Vance?
Yes.
I need your confirmation that you understood what I just said.
I certainly understood what you just said, but let me just, if I can make a brief comment.
Sure.
And certainly at I think the last hearing might have been in June, which went on for quite a bit, not just on the substantive issues of the violation, but also on our contention that the inspector was motivated by racial animus against my client. And there was much discussion of that amongst the board members. And I think at that point, you all might have gone into executive session. So I believe you remember a lot of what had been said. Personally, I have no problem because we're in October, so it was what, a few short months ago. And at least you, Mr. Pincus, I know you have a great memory. I'm not trying to call you an elephant, but I know you have a good memory. And so to the extent that when the board deliberates about this, about these violations in your session that's not public, you discuss those things, that's fine. The only question I would raise, and I don't recall whether at the prior hearing there was actually material introduced into evidence put on the record that addressed the animus issue. I just don't recall at the top of my head. However, in connection with this hearing, I did prepare a packet of documents, I think, which I provided to the board and to the city's attorney, which is labeled Exhibit D, which, and again, I'll leave this to the board's discretion, to simply have those documents admitted that you can review as you choose or not review as you choose. And we can just address the substance of the violations. If you understand exactly what I'm trying to say.
And
So in other words,
sorry.
So in other words, what I would propose is I'll just submit this Exhibit D, which contains the information that we believe is relevant to the animus issue, not discuss it. Since we've already discussed it, it would be the same discussion from the prior consolidated hearing, which quite frankly, I don't think there's any need to get into again. That was quite extensive. But at least the board would have this kind of documentary evidence in front of it concerning that issue, and you can choose to give it whatever weight you determine.
And
okay, Mr. Rulo?
Yes, just very briefly. So I guess the first thing is this is a separate appeal. We can't just incorporate the record findings or testimony from a prior hearing. It's a separate proceeding. And second, the city would object to that evidence being admitted into the record or considered by the board. I would analogize it, and as we've established, it's simply not relevant to the issue before the board. But I would add that I think that this is almost similar to how you're prohibited from introducing insurance information to a jury in a personal injury lawsuit. It's something that is not relevant but can impact the fact finder's decision making. So I understand that the board is going to take the actions it's going to take, but I would just note that for the record that we would lodge that objection to the extent that those documents were being admitted and past testimony incorporated into this matter.
Well,
And one final point, Mr. Pincus, if I can, and I'm not going to belabor this. I know that you can't incorporate prior hearings into this hearing, but essentially what I was referring to was the board's kind of institutional memory, number one. But secondly, this evidence, it's our position, and well, we'll abide by whatever ruling you make. It's our contention that this evidence is relevant to the extent that whether or not a violation is found depends in part upon the discretionary actions of the inspector. So I'll leave it at that.
Excuse me, I truly apologize for interrupting, but may I ask the board to just take a brief executive session?
Yeah, I was about to do that. Very good. We'll take a brief executive session. All right, we're back on the record, Mr. Kelly. And in response to, I'm looking for Mr. Vance, there he is. The issue of exhibit packages actually has already been procedurally resolved, because any exhibits that are sent in when a record is made, should a record be needed for an appeal, they're automatically included in the record. So from our counsel, your exhibits are already a part of the record as we speak. So the only thing that we're asking because of the time of day, and we understand it's been a long afternoon, but we'd like another 10-minute break to allow everybody to take care of whatever functions they need to do. And we'll be back at 4:47, thereabouts, to resume the hearing. 10-minute break. I see Mr. Washington. Well, I see Mr. Washington. I'm waiting for Mr. Patton.
Let's proceed, Chairman. Thank you.
There you go. Okay. All right, so we're ready to resume with case number 40. The appellant is Vernon Lucas. The property is 88. I'm not sure whether it's 88 or 6623 Wayne Avenue. And we'll hear from Mr. Rulo and his witness, and then should I swear in Mr. Lucas at the same time, I guess? Is he going to be testifying, Mr. Vance?
I would just,
Yes.
there's a 15 seconds. I just need to put something into the record regarding the admissibility. If I just may, 15 seconds just for the purpose of the record. So we would just dispute that by submitting evidence to the board, it is deemed admissible and it can be considered as part of the board reaching its decision. So just for the record right now, we're going to maintain our objection as to the admissibility of that evidence on the grounds of relevance, as I walked through before, and that objection carrying over to the board considering it all. So I just wanted to note that for the record.
Fine.
I guess we can swear in both witnesses.
Mr.
Chair,
Chair,
is going to be
just so I'm clear, are we talking about 8823 Wayne?
No.
Well, that's what shows on the list. I just want to make sure that it's not 6623 Wayne Avenue.
It is.
Okay, that's what I'm checking too.
It is 8823 Wayne Avenue.
It's not.
Okay, Mr. Lucas, what's the address?
6623.
It's got to be 6623 Wayne Avenue, since I live 2 houses from the corner of Wayne Avenue, and I don't think that Wayne Avenue goes up that high.
6623 Wayne Avenue.
So we agree it's 6623 Wayne Avenue.
Correct.
Which still probably makes it Westmount area where I live.
So can we make sure that the record is set straight?
The record is that this appeal involves the property at 6623 Wayne Avenue. That's what's listed on the appeal. The list that was sent out to us has an incorrect address.
Thank you.
All right, so the 2 witnesses are Mr. Parisi, am I not mistaken?
Correct.
Inspector Parisi and Mr. Lucas, can I ask you both to raise your right hands? Do you swear or affirm the testimony you give today will be the whole truth and nothing but the truth?
I do.
Mr. Lucas, I don't know if I heard you.
I do.
Very good, very good. Thank you. Mr. Rulo.
Yes, thank you, board members. Inspector Parisi, what is your position with the Department of License and Inspections?
Code compliance specialist electrical.
And do you hold any certifications or other qualifications for that position?
Electrical engineer by education, electrical contractor for 40 years. I hold certifications for the E1, E2, and E3 electrical certifications, which is E1 is residential 1 and 2 family, E2 is all commercial, E3 is electrical plan review.
And what unit are you located in within LNI?
Currently with AIU, audits and investigation.
And in that position, what are some of your responsibilities?
I am assigned by my superior audit inspections to go out on every day to audit and ensure that the third-party inspectors are doing their jobs properly.
Okay. And with the board's permission, I'd like to share my screen.
Yes, and Mr. Parisi, if you have your phone closer or want to speak a little louder, if you're asked questions, that will be appreciated.
Will do.
And Inspector Parisi, can you see what I've displayed on the screen as Exhibit A?
I can.
Okay. And you're familiar with the property on Wayne Avenue that we've just been discussing, correct?
Based on my notes and my photos, yes. It's been a while since I've been there.
Okay, but you have been to the property.
Yes.
All right, I'm going to turn down to 1 second. This first document. What is this document?
That is a licensing violation notice.
And this was issued to, let me know if I'm reading this correctly. The violation number is CF 2024-011-873, correct?
Correct.
And the date of the notice is February 21st, 2024?
Correct.
And this was issued to Vernon W. Lucas?
Correct.
We're going to go down to the violations here, and we will walk through these more specifically in a second, but I'm going to zoom in on this a little bit more because even I can't see this. There were 3 violations that were issued as part of this notice, correct?
Yes.
And what were the 3 violations?
One was a kitchen countertop receptacle in the basement, was not GFCI protected. The water heater requires a circuit breaker lock, and NM cable is not permitted. Romex cable, as we call it in the field, not permitted in wet or damp location.
Okay, and now we'll dive into some of those specifics, starting with the GFCI. Just give me 1 second here. And just for the record, this is City Exhibit B, which is the provisions from the National Electric Code 2017. Okay, and explain most of this to me like I am a golden retriever, which is about accurate for these electrical engineering matters. What is GFCI?
It's ground fault circuit protection. It is to protect personnel from electric shock or electrocution.
Okay, and what I've displayed on the screen here is section 210.8 of the National Electric Code, correct?
Correct.
And this section concerns GFCI?
Yes.
And can you describe like one of so you mentioned that it was in the kitchen that we were talking about.
Yes.
What does this section say in terms of GFCI and kitchens?
Well, that section lists everywhere it's required in a single family or 2-family dwelling. As far as kitchens go, it's where the receptacles are installed to serve countertop surfaces. Sinks where receptacles are installed within 6 feet from the top inside edge of the bowl of the sink.
Okay. I'm going to move down to City Exhibit C. Is this the property in question?
Yes, it is.
Move to the next page. And what is this image displaying?
That shows a inspection sticker that was placed on January 8th of 24 by Vernon Lucas from Sundog Energy Consultants.
And just for the purposes of clarity, the licensing violation notice here was issued to the license that Vernon Lucas carries in his personal capacity, correct?
Correct.
I'm going to move to the second photo. Is this located in the kitchen?
Yes, it is.
And so this is the outlet that you referenced in the violation.
Correct.
What is this device that's in the outlet right now?
The device that I have plugged into that outlet is a circuit tester. It is designed to check polarity to make sure that the receptacle is wired correctly. And it also has a test feature that will test the ground fault to ensure that it's working properly. There's a test button on it that we depress. And when the circuit breaker, in this case, it is not a GFI receptacle. There should be a breaker in the panel downstairs. The lights indicate that when I depress that trip mechanism, the lights are still on, indicating that that circuit is in fact not ground fault protected.
So that was the basis for you concluding that this did not have the required GFCI protection that you referenced, correct?
Correct.
And did this occur after the required inspection, the final required inspection that Mr. Lucas performed?
Yes.
So at this time, all work should have been completed.
Correct.
Okay, just 1 second while I gather my notes. All right, I'm going to return to City Exhibit B. I will zoom in here. So what does this section of the National Electric Code concern?
This refers to a lockable disconnecting means device. If you have a any kind of an appliance that is not within 50 feet or within sight of the circuit breaker panel, you either have to have a disconnecting means at the appliance, or you must have a lockable disconnecting means at the circuit breaker panel to ensure that whoever's going to work on that water heater or other appliance can turn it off at the breaker, lock it out to ensure that nobody accidentally turns it on while the service tech is working on that equipment.
Okay, so we're going to go back to City Exhibit C now. Okay. What is displayed in this image?
That's the water heater.
And this was the area that was the origin of that second violation relating to the, what's it called? The locker?
That's a disconnect lock.
Okay. So can you explain to me what in this photo tells me that that violation exists here?
Well, if you look up by the red PVC water pipe coming out of the wall, you'll see a piece of what we call greenfield conduit, metallic flexible conduit going into the top of the water heater. That is the electrical connection. That's the branch circuit to the water heater. Now, if you don't have a lockable device on the circuit breaker, you're required to have a disconnecting means in that equipment room so that the technician, electrician, whoever's going to, or the gas, whoever's going to work on that water heater has a means to shut off that electric source to that water heater to ensure they don't have to work on a live piece of equipment.
So where would this device be located if it was here?
If it was in there, it could be on the wall next to the main manifold for the water service, or it could be located, like I said, a breaker lock, which is required back at the panel.
And I've returned to City Exhibit B. So the third violation that you noted in the notice of violation concerns something regarding a N as in Nancy, M as in Mike cable. What is that?
It's non-metallic sheath cable. It's interior. It's intended for interior wiring only. It is not rated to be in a wet or a damp location.
Okay, and this section 334.12 concerns NM cables, correct?
Yes, use is not permitted.
And what does this section say about that?
Well, if you scroll down, keep going. We're up, stop right there. Well, if you see B, type NMS cable and go down to number 4, it clearly states it's prohibited in wet or damp locations.
Okay. I'm going to return to City Exhibit C now. Okay. Zoom out. What does this image show?
It shows an outdoor disconnecting means for an air conditioning condenser.
Okay, and this, oh, sorry.
Go ahead.
And this is on the outside of the building?
Yes.
And what would an NM cable look like?
Well, the newer cables are identified by color. This is an older NM cable. And I don't know why they use that, but you can see the paper in it. That indicates to me that it is in fact NM cable, or as we call it in the field, Romex. That's a brand new installation for a condenser.
And so is on the right there, is that the correct wiring that's supposed to be used?
Yes.
Okay. So it's that wiring on the left that is the NM cable.
Correct.
That does it for my opening questions.
Right. Mr. Vance, do you have any questions for Inspector Parisi, bearing in mind that we're asking questions of the testimony the direct testimony that was presented? I believe you understand that.
I got it. All right. So yeah, I do. I have some questions. So, Mr. Parisi,
Inspector Parisi, I believe.
Yes.
So if Mr. Rulo, could you put up, if I can just ask you to use your exhibits, can you put up what was it, Exhibit C, I think it is?
It's the images, right?
Yeah, those are the pictures.
Which one do you want me to go to?
I'll go in order. So just go to the first one.
This is the first one. And just
So
for the
the
record,
first-
this is City Exhibit C.
Right. So Inspector Parisi, this first picture is just a picture of the exterior of 6623 Wayne Avenue, correct?
Correct.
All right, can you go to the second photo? And this is a picture of a document or a tag or a sticker that was prepared by Mr. Lucas, correct?
Correct.
That's, as far as you know, that's his signature from January
Yes, it
8th,
is.
24. All right, let me go to the next photo. All right, now you said that this instrument in the outlet here is called a circuit tester?
Yeah, it's a circuit tester.
And where did you get that circuit tester?
I bought it in an electrical supply house.
When did you buy it?
That one particularly, it's relatively new, probably about a year ago.
In 2023?
I would say, yeah, about 2023. Yep.
All right, so is there any kind of certification or any other kind of document that would verify that this particular tester that we have seen here in the photo was actually accurate?
There are no batteries in these tester types. They work strictly off the voltage of the system. And I do periodically test the device myself at home on my own ground fault devices or on other job sites. So I can guarantee you that tester was working properly.
Was your tester tested or verified to be accurate by somebody other than you?
We don't, these type of devices, we don't have tested by a testing laboratory. They come out listed from Underwriter Laboratory to function. And again, there are no batteries in them to fail. They work strictly off the voltage. There is solenoid inside. If it fails, it's not going to work at all. You won't even see the lights lit.
Right, I didn't ask whether it failed. So the answer to my question is no. Nobody other than you tested or verified the accuracy of your tester, is that right?
Correct.
And when you plug your tester into a particular receptacle, is there any way to tell from the receptacle or from the plugging in of the device exactly when that receptacle was installed?
No, there's no way to tell when it was installed, but it was brand new as part of the job.
Right. All right. So the photo has a date in the lower right-hand corner of February 16, 2024.
Right.
Right.
Correct.
So you don't know when prior to February 16, 2024, that receptacle that's shown in that photo was actually installed. Would that be correct?
That would be correct.
So it could have been installed before Mr. Luke, or I said, excuse me, it could have been installed after Mr. Lucas created that tag on January 8, 2024. Is that correct?
Objection, calls for speculation.
I sustained.
Well, do you know whether that receptacle was installed after January 8, 2024?
Let me put it this way. If
No,
it
that's
was
just no. No, I don't want to hear how we
installed after he was there, then I would have
No.
wrote a violation for missing a receptacle.
Mr. Inspector, I hate to do this to you,
Go ahead,
but you're
go ahead.
being asked a yes or no question.
Yes or no?
Repeat the question.
Yeah, okay. Do you know whether the receptacle was installed after January 8, 2024?
No.
All right. Can you turn to the photo of the water tank, water heater? All right, do you know how far in this particular, well, first of all, let me ask a question. Do you see in the lower right-hand corner of this photo, it says February 16, 2024, 510 West Springer Street, Philadelphia County. Do you see that?
I see it.
Do you know why that address is there?
You would have to ask our IT department why our phones function the way they do. I can't answer that question.
If I can give a little, what is it, not expert testimony, but observation as someone who lives literally a block away from this property. Springer Street is the next intersecting street with Wayne Avenue. And I guess if you stick your arm out, you might trip onto Springer Street when you walk out the door of this house.
But neither you, Mr. Inspector Parisi, nor Chairman Pincus know why that address of 510 West Springer Street appears at the bottom right hand of that picture. Would that be
Oh,
correct?
I don't.
I'm just going to object on the basis of relevance. He's testified that this is the water heater at the property, so I don't know why we're getting into.
I sustain your objection. I don't think we need to go there. We've had this come up before where the addresses on the camera shot don't directly match the property address. But I can at least testify that this is the same within 100 yards of the property that's the subject of this appeal.
Right, but do you know whether within 100 yards of the actual water heater, there's another water heater? I assume you don't know that. So it is relevant why this address is different than the address of the property. I mean, okay, you can take your position, but that is absolutely relevant. Let me ask you this.
Mr. Vance, we'll take notice of the fact that this is not an accurate address on this photograph. Inspector
All right.
Parisi has testified that this is a photograph of the hot water heater he saw on the property on February the 16th. Can we proceed?
We certainly can. Inspector Parisi, do you know, or do you have any recollection of how far that hot water tank, which appears in this photo, was from the panel?
I don't recall exactly how far, but the code states within 50 feet or within sight of. That's the language of the code. So if it's not within sight of that panel, even if it's 5 feet away, it requires a breaker lock device.
Or
So clearly it's not 50 feet. That would be obvious from the photo.
Objection. The witness hasn't testified to that.
That's a question.
Excuse me.
Would you restate your question, Mr. Vance?
Okay. Clearly it's not 50 feet. That's obvious from the photo, correct, Inspector Parisi?
Not really, because I don't really know where the panel's located in this photo.
Oh, okay. You don't know.
It could be on the
Located.
second floor. I don't know.
So you don't know. And you didn't bother to take a picture of the panel, did you?
No, I did not, because it's not within sight of.
I
So
don't.
it doesn't
Let me
matter.
ask you a question. You didn't bother to take a photo of the panel, did you?
No,
And you didn't bother to take a photo showing the distance between the hot water heater and the panel. Is that right?
distance is irrelevant. That's in a closet.
didn't-
It's not within sight of.
Your
Let's
question,
not-
yes or no?
Mr. Vance,
Yes or no?
hold on, Mr. Vance. I believe in my impression, you're being argumentative. Can you try to direct your questions?
Oh, I'm not being argumentative. I asked him a simple yes or no question. He just doesn't want to answer a yes or no.
Well,
So
it-
you don't know. So you didn't take a picture that shows the distance between the panel and the hot water heater, correct? You did not do.
I said I didn't.
Okay. So you have no idea how far that hot water is from the panel. Is that correct?
Again, that's irrelevant.
That, Mr. Parisi, I get it. Gentlemen, slow down, slow down. The question is, do you know how far from the hot water heater the electrical panel is?
No, I don't exactly know the exact footage.
Thank you.
Okay. Do you know what a lockout tagout is?
I certainly do.
What is it?
There's lockout tagouts, and then there's breaker locks to lock breakers in the off position. They are designed to put on a breaker. Lockout tagout is different than what you're trying to get to. Lockout
You know what
tagout,
I'm trying to get to? Just answer the question.
lockout tagout is to lock out a breaker, a disconnecting device, to prevent somebody downstream who's working on a piece of equipment from getting electrocuted by somebody accidentally turning that breaker or disconnecting means back on.
So because you did not take a picture of the panel, you do not know what was on the panel that might have effectively complied with the, let me get the correct description of this, complied with the lockable disconnecting means requirement.
I did not take a picture of the panel. No.
All right. Could we go on to the could we go to the third picture or the next, whatever the next picture is?
This is the next photo.
Yes, the next photo. All right, Mr. Inspector Parisi. Again, look at the lower right-hand corner of this photo. And can you tell me why on this photo there's the address 6627 Wayne Avenue?
I'm just going to object on the basis of relevance again.
Overruled. If you can answer the question, answer the question.
Again, I would have to defer to our IT department as to why our phones act the way they act. I don't know. I can't answer that question, why the address is not 6623.
We'll note for the record that the picture that was taken shows an address at 6627 Wayne Avenue. The property in question is 6623 Wayne Avenue.
All right, Inspector Parisi. I believe you testified that this particular photo shows a connection for an air conditioning condenser. Is that right?
Correct.
So that would be part of this property's HVAC system. Is that right?
Negative.
Why do you say negative?
That disconnecting means is the electrical source to the condenser. It is electrical equipment. It is covered under Article 450 in the NEC, and therefore it is the responsibility of the electrical inspector to ensure it is properly wired and mounted.
No.
Did you look at the electrical permit that related to this property, 6623 Wayne Avenue?
I'm sure I did at the time. I don't recall.
Did the, to the extent that you recall, did the electrical permit that you reviewed state anything about including HVAC equipment as part of the approved work or scope of work?
I'm just going to object on the best evidence rule. This document can be admitted into the record and we can actually look at it.
Isn't it fair?
Yeah, you can. I mean, they're
Hold on a moment. Can you rephrase your question at all, Mr. Vance? We don't have the document before us.
We do.
Excuse me, I'm actually, I believe that the document is in my exhibit packet.
Yeah, that's what I just said. Exhibit D. Exhibit D. Exhibit D, there's 3 pages. Keep going. There's 1.
There it is.
2. Now, and 3. Go to the 3rd one. Okay, now, Inspector Parisi, having seen these documents, do you recall looking at them at the time that you did the inspection that resulted in the violation?
Yes.
All right, and do you recall, and you can look at them now, whether anything in those permits says that the scope of work included HVAC work?
Mr. Rula, can you blow that up for me? Up, scroll up. Scroll up, please. No, not that way. Scroll that way. Keep going. Keep going. Stop. Approved scope of work. It doesn't physically mention every device that's in there. It says rewire all of building new devices and install new 200 amp service for 2017 NEC. That includes everything electrical that belongs to that project.
True.
Mechanical contractors are not licensed to do electrical work, and therefore they are not allowed to do it. We know they do it. However, since it's covered under the NEC, it is the responsibility of the electrical inspector to ensure that it is safely wired and wired correctly.
That's your position with respect to that, is that correct?
Absolutely.
All right, and let me ask you one other question, Inspector Parisi. Would it be correct to say, well, first of all, what is an AFC breaker?
AFC eye breaker?
AFC breaker. Have you ever heard the term before?
I've never heard of an AFC breaker. I don't know what you're referring to.
What are you referring to when you said AFC eye breaker?
That's an arc fault circuit interrupter.
Same.
I'm sorry? Say that again. Say it again.
Arc fault circuit interrupter.
And what isn't, did you say art? fault
ARC.
circuit.
ARC.
Sorry. What is an arc fault circuit interrupter?
What does that have to do with this case? I didn't mention anything about arc faults.
Goodness.
Mr. Vance, Mr. Rulo didn't object, but I'll sustain his objection that I'm not quite sure where that fits into any testimony that's been provided by Inspector Parisi. You need to lay a better foundation of why you're asking this question.
I can't lay the foundation unless he answers the question as to what it is.
Yeah, and I'm also trying to give bandwidth here because I think we want to move this along, but like I'm getting to the point where I'm going to have to object to every single one of these, and I don't know what we're doing here.
You don't have to, as I'm defending my client. But my question is,
I mean, the question is you're defending your client, but you have to ask questions that relate to the direct testimony that Mr. Inspector Parisi has given. So please tell us what question you want to ask Inspector Parisi.
it relates directly to that. If he would just state what is an arc fault circuit interrupter. He testified about how these things have to be placed here and here so that there's no arc and anybody doing work doesn't get electrocuted. We're trying to make sure people don't get killed. So therefore, and he should answer the question.
I made no reference in this case to an arc fault.
Oh my God! Would you just? Are you gonna answer the question or not?
We're getting into argumentative relevance beyond scope of direct. I don't know what list to go on with here.
Mr. Vance,
Are you going to directly answer the
Mr. Vance, will you ask if you want to come back to this question? I'm going to sustain the objection and let you go back to whatever questions that you may have, and it may be appropriate to go back to your question.
I don't know how you're going to sustain an objection that was never made, but let me ask you this question, Mr. Parisi. Isn't it true that because the receptacle with respect to this, isn't it true that because the receptacle was located in a finished basement, that it was protected by this arc fault circuit interrupter?
Again, beyond the scope of the direct.
What receptacle?
No. I'll accept the question. Okay.
Are we talking about GFCI?
Yeah, we are.
That's what I thought. We're not talking about AFCI.
Let's go back before I just
can we go in a breakout room?
Yeah, and let's clarify. I think your question was regarding the ground.
Forget it. I'm not going to ask any more questions. I'll ask Mr. Lucas. Because if you don't want to direct him to answer, you don't want to allow
Mr. Vance, please stop for a moment. Mr. Vance.
I'm withdrawing the question. I'm done. No more questions of this witness.
All right, Mr. Washington, do you want to go to the breakout room?
Yes, sir.
Okay.
Nah, what the hell?
Mr. Vance, I want to try to be as accommodating as I can and allow you to ask questions as you may feel necessary that relate to the testimony that's been presented. But if you've asked a question and it's been answered, or if you're asking questions that go beyond a specific information that was provided and there's an objection, allow me to rule on the objection and then we'll proceed. Okay? I appreciate the vigorousness of your advocacy in behalf of your client.
I have no further questions of this witness.
So, Mr. Rulo, I guess, do you have redirect?
Very briefly. Mr. Parisi, you were asked about, testing the device that you used to plug into the GFCI, to test for GFCI, whether it's present. Do you recall that testimony?
Yes.
Okay. How long had you had that device?
At that time, probably maybe I don't know, what was the date? I forget, probably about 6 or 8 months.
And in the course of that, had it ever given you a false positive?
Negative, no.
Okay, and when Mr. Lucas comes out to do his inspection, at what part in the permitting process does that occur?
It's supposed to occur within 5 days upon the job being completed. So actually, when the job was done and when he did his inspection, I don't have any idea.
So if the department's procedures are being followed, by the time his inspection occurs, does any work remain?
It shouldn't, no. Once he puts a final sticker on it, that job should be 100% complete.
With the water heater, did you see any electrical panel in that photo?
No,
And you testified that you didn't measure the distance to the electrical panel, correct?
correct.
And just to be clear, could you see an electrical panel around that water heater?
I don't recall, honestly.
And turning to the NM cable outside, did you observe, could you tell if any work had been done on the HVAC system at this property?
Say that again?
Could you tell if any work had been done on the HVAC system at this property?
Well, I knew that it was a brand new disconnect and there was a brand new condenser sitting there.
So would that be part of the permit permit work as you testified earlier?
As I stated, the permit said rewire everything. So that would be inclusive of that disconnect for the condenser.
That does it for my questions. And
Mr. Vance, do you have any questions based on the further testimony?
Yes, so Inspector Parisi, between January 8, 2024 and February 21, 2024, when you issued your license violation notice, you don't know whether anyone else did any work to the work that Mr. Lucas had signed off on January 8th. Is that right?
No.
What do you mean, no?
Well-
No, you don't.
No, I wouldn't know.
Okay, all right. I don't have any other questions.
I have a question, Inspector Parisi. I believe there was testimony that and I'm not clear on the technical terms, but the shut-off for the wiring to the hot water heater has to either be has to be visible or at a panel that's within 50 feet.
Code language. The
Could
code
you just
language
verify?
states
Go ahead, please. What's the
within
code
50
language?
feet or within sight of.
I'm sorry, the first part, within 50 feet.
Within 50 feet or within sight of.
So if the panel was within 50 feet of that hot water heater and there was a shut off on the panel, that would comply with code.
Yes.
Thank you. Mr. Vance, do you have a witness you want to put on?
Yes, I would like to call Mr. Lucas.
And it appears that Mr. Lucas and you are not located at the same place. So if you need to confer with your witness, you would have to do it off camera, I presume.
Right, but I will be fine.
Okay.
So all right, so Mr. Lucas, let's address each one of these alleged violations individually. Let's start with the hot water heater. You heard the testimony from Inspector Parisi.
Yes.
As to the basis of the violation, correct?
Yes.
Why do you dispute that?
Well, first of all, he stated 50 feet or within sight. In this case, it was both. It was within sight and within 50 feet. He failed to verify the distance But I'm telling you, it's very rare you'll see in Philadelphia a house that has a basement that's 50 feet long. So we can assume with certainty that it was less than 50 feet. There was a lockout breaker on the panel for that hot water tank. So that's dead. I mean, it's obvious that he didn't verify it. So what else can I say? Secondly, the HVAC is not necessarily a part of the permit. It clearly says on the permit, it said device. That is equipment. It doesn't say that the HVAC system has to be installed. On many occasions, they don't install the HVAC till sometime in the future. It doesn't say you have to put it in. So what happens is left on the HVAC contractor. License and inspections fail to require the HVAC contractor to get a permit to do electrical work. They are not allowed to do electrical work. He's right about that, but they continually let them do that. That was not installed. So that's done. And on each certificate, I put down, because of this issue, this goes back and forth, I'm not responsible for the HVAC, clearly. So that's the next thing. The basement GFCI. Go ahead.
Let me just stop. So what you just talked about with regard to the HVAC related to the picture that had been shown of the wires coming out of the box in the so-called, I think he called a Romex coming out of the box.
Right. That was done by the HVAC contractor.
So you did not.
No, that's not a part of my inspection. And I put that on the certificate. It's clear. He didn't read the cert. If you would have read it, you would have saw on my certification, I said HVAC, not a part of my inspection. Now, if he did read it, that means he just disregarded it and did what he wanted to do. Now, I'm not going to bring up animus because you don't want me to, but that's what makes you think that, well, there's something wrong here. If the guy's seeing something, it's obvious, but he's still violating me over and over again. Without, I mean, it's clear. Okay, I keep going. I won't bring it up. I just did, but I won't again. Now, the basement. First of all,
hold on. Now let me ask you to address the third of these violations, which relates to the receptacle. Hold on, let me just make sure I got it right. The receptacle in which he had placed, where there was a picture of the circuit tester. And why do you believe that violation is not?
Well, first of all, that's not a kitchen. And what happened was I did the inspection, and every receptacle in the basement area has to be arc fault protected, which they were. Work was done after I did my inspection. That's number one. That's not a kitchen. But in the code, if it's within 6 feet of the edge, yes, it should be GFCI protected. Now, he stuck that tester in, and the panel's right behind him. He could have very easily, that tester could fail. He hasn't given us any documentation that tester is correct. We don't know that.
I got an objection on the basis of narrative here. This has been going on for, we're going way beyond the specific.
Objection sustained.
What do you mean?
How are you going to sustain that? He's explaining what he just said.
The question was asked, Mr. Vance, you're coming in and out on my computer, but the question was asked regarding that ground fault interrupter, and I believe Mr. Lucas was pretty clear in saying it wasn't in a kitchen, it was in the basement, and it's 6 feet away, and he also spoke to the tester that Inspector Parisi referred to, and he said it may not be reliable. So at this point,
that's good.
So I think he's answered your question. Do you have another question? I have a question. I have a question for him regarding that testimony. I believe that a receptacle was in the basement, which, unless there was something that said there was going to be a kitchen in the basement, if that's a receptacle in the basement, does the same requirement pertain? That's for a receptacle above a kitchen sink?
No, only if a sink is there. If it wasn't a sink there on my inspection, it doesn't have to be GFCI protected, it has to be arc fault protected. And that's where Councilor Vance was leading to, where you guys cut him off. He asked to explain what an arc fault AFC in the field, what we call the AFC.
So your testimony is that receptacle was in the basement, and as far as you recall, there wasn't a sink right there.
It wasn't, and I don't even know if that receptacle was there, because the next to where over the sink was, it was in the floor, like. So they added another receptacle, which is okay. It's his house. I don't care, but that's after my inspection. So I mean, you can't. If anybody's to be violated, it's the owner. He did work. It's to be two people should be violated here: the owner and the HVAC contractor, and L&I for inspecting work and approving work. That's not right. It's three people. I said two. It's three.
All right.
I mean, what are you going to? It's three.
I think pretty much. I really don't have any other questions. Other than, excuse me, with respect to this last thing, the receptacle. But your testimony is that with the arc fall protection, that receptacle was still protected, the one that's in the photo. Is that right?
All he had to do was look behind in the panel. He didn't do it. He just stuck that thing.
All right, you've answered his question, Mr. Vance.
Yeah. Okay. That's it. I don't have any other questions.
Mr. Rulo.
Yes, and I'll try to be brief.
Oh, please.
I appreciate that, Mr. Lucas, and I will actually try to be brief.
I got it.
What is your role in terms of inspecting these properties?
What is my role? I am the inspector. It's evident. I am the inspector. In most cases, the authority having jurisdiction, which was bestowed on me by license and inspection when they gave me my third-party agency.
So you're supposed to inspect after all the work has been completed?
Yes.
Okay. And you testified that there was not a sink near that outlet on the countertop that we looked at, correct?
It wasn't a countertop or a sink there.
Do you have any photo showing that?
You got my testimony. Sworn testimony, it wasn't there.
And then in that photo of the water heater, you'd agree with me that there was no electrical panel in that photo, correct?
It didn't have to be. It only had to be within 50 feet.
Yes or no answer?
Say that again?
You'd agree with me that there was no electrical panel in that photo of the water heater?
Oh, in that photo? No, there was not a panel in that photo. No, there was not.
And do you have any photo showing where the electrical panel was located in the property?
Well, like I said, no, I don't have a photo, but it was within 50 feet. The basement that you can go pull up the specs on the house, and the house is not 50 feet long. It's obvious. Come on now. It's
so
not.
You haven't, am I correct? You haven't measured how far that is away from the water heater, correct?
I did like Bob Parisi. I didn't measure. When I did my inspection, I looked at it and I said, this is within 50 feet.
Mr. Rulo, I believe he's answered your question.
And I'm done.
Thank you.
All right. I think we've heard testimony from everyone. Do we want to hear, we are obliged to hear closing argument from counsel, Mr. Vance, and then from Mr. Rulo, and then we'll adjourn for a brief executive session.
Sure, I'll be as brief as possible with respect, and I'll go in reverse order. So with respect to the receptacle, which was the first photo where the tester was put in, Mr. Lucas testified that there was no countertop or sink when he completed his work. That work was done after he did his work. But in any event, with respect to with respect to that electrical outlet, there was I think it's a lockout tag or something like that that would have an arc protector that would have protected that electrical outlet so that nobody would be electrocuted. So again, that's that electrical thing, and it was not a kitchen. It was not a kitchen. That thing was not a kitchen. It was in the basement. With respect to the HVAC. He didn't install the wires that are on the photo that the city shows you. That was done by the HVAC contractor. He put on the permit that he was not doing any HVAC work. And according to him, this was equipment, not installation, which would have been the responsibility of the HVAC contractor, not the inspector. And it was done after he finished doing what he was doing, and he didn't install it. So he should not have been violated, and according to him, it should have been the HVAC person. And finally, with respect to the water heater, he testified that the necessary protection was the lockout breaker was on a panel of that was within 50 feet and within sight, and there was no therefore there no violation of the code section that was referenced by the city's attorney. The bottom line is that there's no basis for the violations, and that if anybody should have been cited, people who should have been cited were the ones who came in who did work between January 8th, 2024, when he signed off on his little tag, and February 21st, 2024, which is almost 2 months after that, when Inspector Parisi came in and did his inspection and worked the violation. That's it.
Very good. Thank you. Mr. Rulo?
Yes, just a couple of points. First, and I think this is key, the way that this process is supposed to work is that Inspector Parisi goes out after all of the work is completed. That is the only time that he goes out to do this. On the first, and the second thing is, for each of these violations, the city has provided photos to back up our testimony, Inspector Parisi's testimony. There have been no photos offered by the appellant to come up with contrary evidence. The third thing is, in some of these instances, like with the GFCI, we have walked through today each of the sections of the NEC that was the problem. And then we showed in each of the photos where it was violating that specific section. And I think the GFCI is an example of that, is unless the board is to accept that the device that Inspector Parisi was using for months and months was defective, that violation exists. So in this instance, we believe that the other aspect of this is just to read again what that permit says. Rewire all of building new devices and install new 200 amp service for NEC. Inspector Parisi testified that that was a new HVAC system. As a result of that, we believe the violation should be upheld.
Very good. Thank you, gentlemen. Let us take a hopefully less than 5-minute executive session.
Okay.
Been here, and everyone who's been here, thank you all for your patience. We've had an interesting afternoon, I think. Let us call for the vote. My vote is city affirmed.
City affirmed.
Feel sustained.
Vote is city affirmed 2-1 sustaining the appeal. As a result, the decision is to affirm the city. You have the right to appeal the decision that was issued by the board. Any questions, gentlemen? Thank you, Mr. Rulo. Thank you, Mr. Vance, for your vigorous presentation.
Thank you, board members, and have a good evening.
And Mr. Rulo, thank you for your calm demeanor during the vigorous presentation.
Of course. Thank you. Good evening.
Thank you all. That concludes the business of the board for this afternoon.
All right. May I be excused, Mr. Corsi?
Everyone is
Adjourned.
excused. This will end the hearings for